SAS, medical examiner for Dunn County. Met her at the Olson Funeral Home, where the victim was located. We secured the victim and we transported to the Ramsey Hospital in the cities, to the medical examiner's office there. Yeah.
And when you assisted with the transport to the Ramsey County Medical Examiner's office, when the body was picked up from Olson's funeral home, was the bag secure?
Yes, it was. It had a lock on it.
And you followed the body all the way to the Ramsey County Medical Examiner's office?
I rode with medical examiner Rosas. I was in the passenger front seat and she drove.
And did you or anyone else tamper with the body in any way?
No.
What happened, I guess, let me start over. Were you present during the autopsy of Alex?
Yes.
What was your role during the autopsy?
Just simply to make sure that the evidence was not tampered with and secure, and I was there to observe the entire time, not much past that.
And do you know what happened to Alex's clothes after the autopsy?
Yes, the medical personnel there, they hung it on a nearby table in the autopsy room because there was concern that might not be completely dry. They didn't want to present a bigger biohazard than needed be, so they were going to dry it out, secure the evidence later on.
And then before you went to pick up Alex's clothes, did you assist in executing a search warrant at Alex's house at 511 Cameron Street?
Yes, I did.
And were some items seized from Alex's house in case they had any evidentiary value?
Yes.
May I approach?
You may.
I'm showing you what's been marked as Exhibit 648. What is that document?
This is the Dunn County Sheriff's Office property inventory record. There's Investigator Rod Dyke's name at the top of it.
And does this contain the evidence that was seized from 511 Cameron Street?
Yes, it indicates items 37 through 48 here. I'm sorry, through 52.
And was a black Asus laptop, computer, and charger from the bed seized during that search warrant? Yes,
that would be the item indicated by item number 37 on this form.
Can we get a spelling of that?
It would be ASUS. Thank you.
And was a yellow Amazon tablet taken?
Yes, this is item 38 on this form.
And was a Samsung tablet with a pink leather cover and keyboard taken?
Yes.
And do you recall seeing a number of books located on a bookshelf during the execution of the search warrant?
Yes.
May I approach? Sorry,
Yes. You may approach.
I'm showing you what's been marked as exhibits 645, 646, and 647. Do you recognize seeing these items during the search warrant?
Yep, I do.
And I request to move these into evidence and request to publish them for the jury.
No objection. So that's 645, 646, 647?
Yes.
Those will be received. Are you offering 648?
No, not at this time.
Okay. You may publish them.
I'm first showing you exhibit 645. And what is depicted in this photograph?
It's a bookshelf with several books and some journals.
And if you were standing outside and walking in the room, is this what you would observe?
Yes.
I'm showing you 646. What's depicted in this photograph?
Same thing, closer shot.
So there are two large bookshelves.
Yes.
And exhibit 647. What's depicted in this photograph?
It's a trunk and various items right next to a mattress lying on the floor. The mattress would be to the right side. This would be immediately to the left.
And it appears that there's a book on the trunk there. Are you able to make out any words on that?
Adieu to Emmanuel Lebanon, I think it's Lebanos or something.
And that was the book that was located next to the bed when you executed the search warrant.
Yes, it was.
And looking at that property inventory sheet, that book was not taken as part of this case, is that right?
Correct.
I'm showing you it's been marked as Exhibit 649.
Yes.
Is that item number 39 if you look at Exhibit 648, the property inventory record?
Yes.
And what is Exhibit 39?
Book entitled Corpus, C-O-R-P-U-S, by the author Jean-Luc Nancy,
And where was it taken from?
from a backpack in the victim's bedroom.
And if I put back up on the screen, Exhibit 647, is this the backpack it was taken from?
Yes.
And could you open that book for the jury, please? And if you could just come forward and publish that book for the jury, please.
Come forward and what?
Just publish the book for the jury. And I'd move Exhibit 649 into evidence.
Any objection? All right, 649 will be received, and counsel would appreciate if you would be in evidence before it's published to the jury.
Sure, sorry, Your Honor.
Thank you.
On March 29th of 2018, then do you recall returning to the Ramsey County Medical Examiner's Office to pick up Alex's clothes?
Yes.
And how were the clothes packaged?
They had them individually packaged inside of a box. It was never necessary for me to go inside that box.
May I approach?
You may.
I'm showing you what's been marked as exhibit number 650. Do you recognize that document?
I do.
And what is it?
It's the evidence log from Ramsey County, and it's receipt number 5651.
And is that your signature in the bottom left-hand side?
Yes, it is.
And this, does this document list the number of items that you took into your possession on March 29th, 2018?
Yes.
And there's a sentence at the bottom that the contents of box was stapled closed but not sealed. Is that your handwriting?
No.
Okay. I'd move exhibit 650 into evidence.
Any objection to 650?
Maybe if we get the publication, I gotta look at it closer, but no objection to it taking this minute.
All right, 650 will be received.
And so what, if anything, did you do with the items when you returned to the Dunn County Sheriff's Office.
Run back, straight back to the Sheriff's Department, consulted with one of our evidence technicians, one of our two evidence technicians, Rich Day. We mutually agreed that it would be held in a temporary storage until he could facilitate further processing of that evidence. So it was locked in that temporary storage locker inside the locked evidence room.
I would now like you to come on down, and I'm going to have you open a number of these items. Do you want to wait, Judge, before we do this until after lunch, or do you want to do it now?
Food here.
It's not here yet, but I was told to move.
Okay, well, let's go until we are notified the food has arrived for the jury. If you'd like to wait till after lunch, that's fine. I think maybe it's so close to 12, I think that maybe that's what we'll do. So, ladies and gentlemen, I think we're going to take a renewed break. Probably be about 1:05 or so. When we bring you back in, we'll try to keep it on schedule. Okay, all rise.
I didn't know if Your Honor wanted to cover the sidebars, but before we get to that, I don't know if the state's obviously not done, but I wanted to just give Court Officer Moen the heads up that the defense is going to want items 40, 41, 44, and 45 from Exhibit 648. So I don't know if they're on the other side of the rail there, but if we're on a lunch break, I thought now would be a good time for me to let them know that I intend to cross them about other physical items that are on that list, and those are the ones.
Okay, we'll go back to sidebars, get those cleaned up before we break for lunch. The most recent sidebar was just before the presentation of Exhibit 331 before the jury, and basically the sidebar was to reiterate the defense objection to the showing of those photographs. They were redacted in a manner that was consistent with what the court had said on Friday evening. The nipples were covered for Ms. McCandless. Wasn't a full bar across, but the defense noted their objection, and I just had noted that the objection's noted. Is there any further record either counsel would like to make with respect to Exhibit 331 in that sidebar?
No.
Judge.
Okay. A previous sidebar, 10:49 a.m., and that related to Exhibits 322 and 326. They were published to the jury, however, they were published in the hard copy photograph form and not published through the courtroom media presentation equipment. And those related to photographs of Ms. McCandless. One, I think it was a full body shot from the rear with just underpants on, and the other with pants on but no shirt on. And out of respect for Ms. McCandless' privacy and not having undue embarrassment, the court did sustain an objection to 322 and 326 being projected on the screen and again shown through the media system. Any further comments counsel would like to make? Mr. Nelson?
No, thank you.
Ms. Nodahl?
No.
All right, and then that takes us back to the sidebar at approximately 9:50 a.m. and that related to some questioning on cross-examination of Dr. Tillotson by Attorney Vishny and the area of BDSM, and there were some questions about knife play. The court had indicated it essentially sustained an objection but allowed the defense to ask one more question, and that was basically whether Dr. Tillotson was familiar with that. And counsel went on, the question was asked, and he was not aware of it, so that was the end of that particular inquiry. Anything further either counsel would like to make a record on that particular sidebar?
No.
Okay. All right, any other sidebars that I have missed?
No, Judge, there is one matter I want to take up before we're back, though.
Okay. When you're ready.
Your Honor, on this property inventory record from the search warrant at the victim's residence, seized from the victim's residence were 4 different condoms.
We agree that those are irrelevant and should be blanked out. We're not going to mention it.
Okay, then that's settled.
So there won't be reference made of it?
Right, the state's position is those condoms are irrelevant.
All right, the defense agrees?
We're not going to make, we agree that we're not going to make mention of them in 648. I can't imagine a way that they're relevant, but for this witness at this time, I agree.
Okay, very well. Anything further?
No.
Okay, then we'll have our noon recess, and I ask counsel to be ready to proceed at 1:05 p.m. with the next witness.
Officer, are you able to read that? Okay.
Yes.
Would you mind reading what that book is about for the jury?
Talked about it?
Yes, please.
Okay. So praise for corpus. Jean-Luc Nancy gives us bodies in their gravitational weight, their mutual touch, their joy and their devastation, their self-evident presence and their constant elusiveness. From the dazzlingly layered complications of the opening corpus to the meditatively personal accessibility of the closing, the intruder, these essays display the necessary connections and mutual exclusions of flesh and word. Nancy's work on bodies, already canonical, engages traditions we thought we knew. Platonism, Cartesianism, Christianity, and shows us how much newness is possible still. By Carmen McKendrick, Lemoyne College. Next paragraph, how have we thought the body? How can we think it anew? The body of mortal creatures, the body politic, the body of letters and of laws, the mystical body of Christ. All these and others are incorporated in the word corpus, the title and topic of Jean-Luc Nancy's masterwork. The long-awaited English translation is a bold, bravura rendering. To the title essay are added 5 closely related recent pieces, including a commentary by Antonio Birnbaum, dedicated in large part to the legacy of the mind-body problem, formulated by Descartes, and the challenge it poses to rethinking the ancient problems of the corpus. The last and most poignant of these essays is The Intruder, Nancy's philosophical meditation on his heart transplant. The book also serves as the opening move in Nancy's larger project called The Deconstruction of Christianity.
That's good. Thank you very much. And officer, this is the book that was located in the backpack near Alex's bed. Is that right?
Yes.
And then if I could ask you to get a new pair of gloves on and come on down to open some of the items that you picked up from the Ramsey County Medical Examiner's office. I'm going to have you start with Exhibit 227.
Okay. Open it.
Yes, what does it indicate? Is it inside?
Scarf.
Okay, yep, if you could open it. 227. And is that the scarf you remember from the autopsy?
It is.
And are you able to, do you observe any cuts or anything on that scarf?
I don't see any cuts.
Okay. Thank you, and move exhibit, is that the same scarf you remember from the autopsy?
Yes, it is.
Okay, and move exhibit 227 into evidence.
Any objection to 227?
No objection.
Exhibit 227 will be received.
And if I could have you move to exhibit 228, it would be the sweater.
Okay, so the primary book on Alex Woodworth's main journal. So it's a Alex Woodworth's journal titled Extra Skiver, along with his notebooks and philosophical texts, focused on a deep, dark, and highly unsettling thoughts about human nature, isolation, and cannibalism, violence, and self-sacrifice. Woodworth was the 23-year-old barista and aspiring philosophy professor. He used his journal to work through the complex abstract taboo concepts. When the defense brought these writings to light, they highlighted several specific and disturbing themes. Cannibalism and violence. Woodworth wrote explicitly about cannibalism, physical destruction, exploring what it means to completely consume or be destroyed by another person. Nihilism and loneliness. The entries heavily featured his struggles with extreme internal pain and loneliness, questioning the value of existence, coming back from the dead. He wrote abstractly about himself, individual who comes back from the dead, dealing with themes of dark rebirth and self-sacrifice. Dark romanticism. He often tied romances to pain, writing about love as something inherently destructive and violent. Aside from Extra Skiver, River, the court discussed several other specific titles and journals found in his possession that carried similar tone. Quote, he said, I met a man walking through a barrier patch. This was a leather-bound ledger book where Woodworth wrote about seeking the rose promised by thorns, focusing heavily on finding beauty through immense pain. Yes, exactly, Anna. And that is true. There was some testimony earlier that I had to put earmuffs on. I got the earmuff alert, and I put the earmuffs on because there was some too spicy of a testimony that happened. Fear and Trembling by Surin Kierkegaard, a famous real-world philosophical book found with his things. This book focused heavily on psychological anxiety of faith, the concept of sacrifice, whether a person can be morally or justified by deleting someone if commanded by a higher purpose. I See You, Duke, the Chickens, Bubbles, Claude, and the Space Yeti, and the Swamp Puppies, and an Alien. Corpus by Jean-Luc Nancy, a dense philosophical text exploring physical human body, touching on how bodies experience touch, weight, injury, and death. Why meaning mattered. The defense argued that because Woodworth shared these dark writings with McCandless during their relationship, they were just harmless school notes. They claimed the book was his real-world desire, fulfilling McCandless' head with fear, making her believe he was capable of carrying out violent acts about those things. Jason Stalker was on the stand a little while ago, but not from Jason Engel. That hasn't happened yet. Okay. So now we'll continue with the trial.
And is that the same sweater you recall from the autopsy?
Yes, it is.
Again, just a reminder, let's not be published into the jury until the item of evidence is received.
If it's helpful, Judge, assuming this is all of Alex's clothing, we do not object to the admission or the publication.
All right.
Okay, thank you, and move Exhibit 228 into evidence.
Okay, Exhibit 228 will be received.
Next, if you could open 229, which would be a sock.
Are you offering 229?
Yes, please.
Okay, 229 will be received, and again, you may publish.
Okay, thank you. And if you could turn to 230, the other sock.
Are you offering 230?
Yes.
230 will be received. May publish.
Thank you, and if you could show the jury as well. All right, and then if I could turn to Exhibit 231, I believe that's the underwear, and I'd move Exhibit 231 into evidence.
Exhibit 231 will be received.
Can you show the back of it as well to the jury? Thank you. Okay, thank you. And then Exhibit 232 is the last one. I believe it's the pants with a belt.
With belt, yes.
Move Exhibit 232 into evidence.
232 will be received and may be published.
Thank you. And you can take the gloves off. I don't have any further questions for Officer Kurtzels.
All right, any cross-examination?
Yes, please.
Kurtzels.
Kurtzels. Mr. Kurtzels, you mentioned when you first got there, you brought a report with you, is that right?
Yes.
You've made out a police report, or what we commonly call a police report regarding this, correct?
Yes, sir.
You initially, you said you were the sergeant of investigations?
Yes.
Does that mean basically you're in charge of the investigators?
Yes.
Okay. And so, a case like this comes in, there's somebody that's deceased, there's an investigation about a homicide, you're in charge of task assignments, as well as probably lots of other things, but certainly assigning tasks.
Correct.
What else?
Overseeing the entire operation, everything from the initial securing of the scene to collecting the evidence, interviewing potential witnesses, calling in the state crime lab for their assistance, calling in the Wisconsin State Patrol so they can do a schematic to scale of the area, securing search warrants, maintaining the evidence, making sure the chain of evidence is followed correctly, that the evidence is secured in a fashion where it's not compromised, doing complete reports, making sure that everybody involved in the process, investigators, people from the crime lab, Wisconsin State Patrol, ambulance crew, they've all submitted their required reports. Conducting follow-up investigations, consulting with the district attorney, having follow-on briefings, progress briefings with everybody that was involved. We had several of those, all the way up until today, my duties here in the court.
At some point, you're in a different uniform than Dunn County Sheriff's Department, right?
Yes, sir.
When did you leave the Dunn County Sheriff's Department?
January of this year,
Okay, January of 2018, of 2019.
19th.
I just made a mistake. Do you know who took over your role as Sergeant of Investigators after that?
I don't believe they have a sergeant in that section anymore, it's just investigators now. Now they fall under the bailiwick of, I believe,
They fall in what?
the bailiwick, the supervision of someone else, not a sergeant of investigation. I think they've restructured that.
Okay. And when you left Dunn County Sheriff's Department, I imagine your responsibilities of overseeing the entire investigation of this case left when you left the job, correct?
Correct.
I mean, you're still here telling us about what you did when you worked for Dunn County, is that right?
Correct.
But once you left Dunn County, you haven't done any additional work since January of 2019 other than your testimony in this case, right?
That's right.
And as the Sergeant of Investigations, a lot of people are giving you information, correct?
Yes, sir.
And basically, you're collecting information from other people in law enforcement, right?
Law enforcement, the state crime lab, I suppose you can consider them law enforcement, EMS personnel, witnesses for witness statements, those
Okay.
sorts of things. Yeah.
And sometimes in your role, you're also making out reports, as you did in this case, right?
Yes, sir.
And in your reports, you're again wanting to gather up all the information that's been provided to you and document it in some way, correct?
Correct.
And in this case, you made out a report in which you wrote down some of the information that you've gathered, correct?
Yes, sir.
Including that, quote, she had superficial cuts on her lips, neck, hands, and the word boy scratched into her arm, correct?
Correct.
So you had written in your report documentation of a cut to her neck, is that right?
Correct.
And that was information that you had got as the Sergeant of Investigations, correct?
Right.
You took place, you were there at Alex Woodworth's apartment, is that right?
Yes, sir.
And we saw some of the photos. Do I need gloves on to move that book, or can I just move it?
I think you can move it personally.
Just
Okay, do you want to use gloves or for any reason?
I have no reason, I'm just, don't want to make a boo-boo here. Does anybody want me to use gloves? Otherwise, I'm just going to pick it up and move it.
Why don't you speak up?
Great. Pictures of.
I think there's 645, 647.
45, 6, and 7. The photos, 645, 646, and 647 up there. Oh, we found it.
I might have taken
So I want to ask you some questions about these photos that you previously testified about, okay?
Yes, sir.
I'm going to just put them up on the screen so we can all know what we're...
Have those been received?
Yes, I believe they have.
Oh, yes, they're there.
Permission to publish, I think they already have.
Thank you.
Showing you what's been marked as Exhibit 646, is that right?
Yes, Amy?
Yes, sir. That's the picture of the bookshelf from Alex's apartment, is that right?
That's correct.
And there's, fair to say, nearly 100 books. We haven't counted them, neither you, or at least I haven't. Have you counted the books?
No, sir.
But you'd agree it's...
That sounds fair.
Oops, went the wrong way. There we go. And of the books that we're talking about, like this book corpus and some of the other books I'm going to ask you about, this wasn't on the shelf, was it?
Correct.
The book corpus, which is exhibit...
$648.
649, I believe.
Okay.
648 is the evidence log.
Correct.
649 is the actual book. That book was not on that shelf, agreed?
Yes, sir.
Where was it?
In a book bag on the floor, to the left of the mattress on the floor.
Okay. And so on exhibit 648, that's the evidence list, is that right?
Yes.
The item number 40, we'll eventually open these up, but I just want to go through the list here. Item number 40, a journal titled Dream Tree, Simple and Elegant. Was that found in a backpack on the floor?
Yes, sir.
Same backpack that had this book corpus?
I believe so.
Item number 41, a leather cover journal with notes and writings. Is that also from the backpack?
I do not know.
Item number 44, a ledger book containing writings of Alex Woodworth. Was that also from the backpack?
I don't know.
Item number 45, a book entitled Fear and Trembling by Soren Kierkegaard. That was from the bookshelf according to this?
Yes, sir.
Other than the book Fear and Trembling, did anyone collect any of these other books that we see the spines of in this picture here?
To my knowledge, no.
Were you the one that picked out Fear and Trembling and decided to collect that in evidence?
No.
Do you know who did that?
No, sir.
So you would be able to say why that one book in particular was taken out?
I don't know.
Why don't we, do you have Exhibit 45 there, or Mr. Moen might be able to help us? If you could bring out 40, 41, 44, and 45, please, sir.
41, 44, okay.
40, 41, 44, and 45, please. And the item, the numbers that I just gave you are item numbers. Thank you. Item number 40 from Exhibit 268 has been individually labeled Exhibit 651, is that right?
Item number 40, 651, yes, sir.
I'm sorry, the exhibit number is 268 or?
It's exhibit number
Exhibit 651
651.
is item 40 on the list on Exhibit 648. Agreed?
Yes, sir.
Exhibit 652 is item 41 from the list on Exhibit 648. Agreed?
Yes, sir.
Exhibit 263 is item 44 from the list on Exhibit 648. Agreed?
Yes.
And Exhibit 654 is item 45 from that same list on Exhibit 648. Agreed?
Yes, sir.
I look at yours.
Yeah, absolutely.
I'm going to ask you to open up Exhibit 654, sir. Open it, but just don't pull it out yet.
Yes, sir.
And if you can just peek in on your own, but don't show anybody else, just peek in on your own.
Okay.
Does that appear to be the book title that's listed on exhibit? Move for the admission of the exhibit in your hand, sir. 654.
Any objection to 654?
No objection to any of the evidence.
Permission to publish.
All right, 654 will be received. Are you also offering 651, 52, and 53? State is not objecting, so
I will be offering 651, 652, and 653, and 654, yes.
okay. So those items will be received. We have those, Madam Clerk? 651 through 654.
Permission to publish all when they get to that point.
You may.
What's the book in 645? Can you pull that out, show the jury?
It's 654.
654, I transferred the book until,
Fear and Trembling.
why don't you pull it out and show that?
I'm sorry, can you repeat what you said?
Fear and Trembling.
Can you again display, show that to the jury?
Everybody see that?
Wherever you're comfortable, sir, I'm going to ask you some questions about that and the other exhibits. You're welcome to go sit down, you're welcome to stand there. I want to tell you where to go, wherever you're comfortable.
Okay.
What you're telling us is the book Fear and Trembling from Exhibit 654 was found on the bookshelf, is that right?
Yes, from the short bookshelf.
Okay. And you don't know why that book in particular was the one and only book taken from that bookshelf, do you?
I do not.
You know, when you did it, it was just law enforcement in there, correct?
Correct.
There was nobody from the prosecution team there, agreed?
Agreed.
There was nobody from, no defense attorneys that were there in any way, right?
Right.
It was just law enforcement, right?
Yes, sir.
And some law enforcement officer made a decision to collect and pick that book out in particular, right?
Yes, sir.
Have you familiar with that book?
No.
Okay. The other book that we had you read, are you familiar with that book, other than you just read the back?
That's not my type of book.
I appreciate that. Same thing with the Fear and Loathing, that's not your type of book?
Correct.
And do you know anything about the book other than what's on the cover?
Nope.
So you're just saying that's not my type of book based upon what you see on the cover, right?
Correct.
Okay. do I have permission to put that on publish it on the screen?
Go ahead.
Is there any reason, again, I can't pick it up, or I'm just gonna pick up the evidence pieces and I won't touch the book? Do you know, did anybody take an inventory of the other books that were on the shelf here?
No.
Okay. Just these two photos, 645 and 646, are essentially the documentation that we have of what would be in Alex Woodworth's library, right?
Yes.
The book shown in Exhibit 647, that book, does it appear to be written by Derrida?
Close to that, yes.
Jacques Derrida, D-E-R-R-I-D-A?
Yes.
That book was not collected?
To my knowledge, no.
Okay. Again, probably not a book that you're familiar with or know anything about?
That would be correct.
Okay. There was some other books that were, other items that were collected from the backpack, is that right?
Yes.
And that is the items 651, 652, and 653. I'm going to ask you to open those now and display those to the jury. We could just go through them each so you can,
Go ahead.
And the item that you just pulled out of that was out of Exhibit 651, is that right? That's correct. And the title of that is Dream Tree, Simple and Elegant. Looks like that was printed, pre-printed on that, what we'll call a journal, is that right?
Correct.
And then on the front it says, Notes, October 19th, 2017 dash through, is that right?
Yes, sir.
It says something similar on the binding, is that right?
Yes.
Can you just open that up? The first page, is that signed by somebody?
Alex Woodworth.
From October 19, 2017 is what it writes.
Yes.
Reads, correct?
Yes.
And can we turn to the first page just to, it appears the first entry is October 19th of 2017?
Yes.
And then if we can scroll all the way to the, we don't have to go page by page, sir. Go to the last page just so we can get an end date if there is.
Looks like,
It ends on page 37.
that's what it looks like, yes.
And it appears to be, actually if we can go back again. That entry appears to be undated, or maybe it's the November 20th, 2017 date?
Correct.
Okay. And on the top of page 35, it appears to be making reference to Corpus by Jean-Luc Nancy, correct?
It does.
That's the same book that we previously referenced, correct?
Yes, sir.
Okay, thank you. Do you know, as you're, if you can open that up, on page, again, can I, any objection to my handling it, Your Honor?
Well, even perhaps you should use a glove.
That's fine.
One here.
Well, if you don't want to make you have to do things, but if you're gloved, are you helpful, can you come over this way, sir? Can you show on Can permission to publish, Judge?
Well, publish what? We're not going to go through that whole thing right now.
I'm not going to go page by page. There are particular markings that I just want to reference.
No,
Can I,
what do you have in mind, time-wise?
again, I'd have to look at it, but I think there are, where do you want to go? One, I'm just looking for other page numbers here. Oh, sure. Four doodlings I'd like to ask him about, Judge.
Judge, can we have a sidebar on this?
Yeah, let's have a sidebar. All right, you may proceed.
Thanks. I just, while we were standing here in the courtroom, you kind of quickly breezed through the book and you noticed four different doodles, is that right?
I did.
At page 1, page 25, page 27, and page 35, is that right? Correct. Could you show us the doodle on page number 1?
I'm sorry, can I hear this page numbers?
1, 25, 27, and 35. There it is. So what's displayed up on the screen, oh, I guess you can look behind me too, that's fine, is the doodle from page 1, is that right?
Yes, sir.
Okay. Can you show us the one on page 25? Again, that's the a cat with some hearts on it on page 25?
Yes.
And then the page 27, that appears to be some other object perhaps orientated upside down from the way we're viewing it now. Does it appear to say the word peach next to a drawing of what may appear to be a peach?
Yes.
And then on page 35, is there another doodle there?
Yes.
Okay. Thank you. That's all the questions I have about that. We can move on to the next exhibit, sir. Take whichever one you want, that's fine.
Got 652 here?
Thank you. When we're done with this one, I'm going to ask you to open the other one too. So whether you want to do them both at the same time or not, I'm going to defer to you, but just wanted to let you know where we're going.
Okay. So this would be number 652.
Read the front cover there.
Just now, as I'm reaching the end and everything is finished for me, I know that I have to start all over at the beginning.
That's the writing from the, is that the back cover?
That's the back.
And what's the front say?
I met a man walking through a briar patch. He was looking for the rose promised by the thorns.
If you can open up the, what does the front cover say?
For a God who isn't, signed by Alex Woodworth.
Okay. And that journal, that book, if you start, there's a table of contents.
There is.
Can you turn the next page?
Wait, no, let's go. Page 20 is the last page.
All right, so there's 20 entries in there, is that right?
Yes.
And there's a table of contents in the beginning that's accurate to the first couple of writings, but then there's some included that aren't on the table of contents, is that right?
Correct.
Okay, thank you. What's the next exhibit then, sir?
So the next exhibit would be exhibit number 653.
Pull that out on the front cover. What is that? There you go.
You want me to read it?
Yes, please.
Extra Shriver, September 2017 through February 2018, plus from the past.
Can you perhaps display it on there so we can all see the writing? There we go. Great. Sorry, if you could then just again, does it seem to correspond with the dates on the front cover there? What's the front, when you open the book, what does it say? Is there a name in there?
Alex Woodworth.
Okay, and then as you just, again, just briefly, let's go to the front page and then the last page. Is there a table of contents?
There is,
And does it start with October 23rd?
2017, yes.
And there appears to be, at least on this front, 20 different writings that are referenced on that, is that correct, on the front page?
On the front page,
And then if you turn the page, there's another 25 to go up to number 45, is that right?
yes.
And then as the journal is essentially filled, is that right? Does it go all the way to the end?
All the way to the end.
Ends at page 192,
It does.
and that's dated February 3rd, 2018.
Yes, sir.
All right, thank you. Those are all been admitted, is that right, Judge? Yes. Okay. Those, just, the three items that we just opened up, 651, 52, and 653, just, do we informally agree to call those journals?
Yes.
Those journals were all found in a backpack? Is that your understanding?
I don't know if they're all found in the backpack.
Okay.
At least two of the three.
Okay, and where was the... And the two of the three were, which ones? You can just tell me that item number and all.
The leather, item number 41, leather cover journal.
So exhibit 6.
I'm not sure if that came from the backpack or not.
Okay, exhibit 652, item 41 is the one that you're not sure where that came
Yeah,
from.
I don't know where that came from.
Okay, but exhibit 651, which was item 40, that came from the backpack?
It's, yes, yes, sir.
And the one we just talked about, the extra Scrivener, exhibit 653, that came, item number 44, that came from the backpack?
I don't know where that one came from.
Okay.
So it's one of the three that I can definitively say came from the backpack. I don't know about the other two.
And you don't have a memory as you sit here today where it was that those came from?
No, sir.
Okay. As part of this case, you also sometimes took direction from District Attorney Nodoff, is that right?
Yes.
one of the directions that you took was to follow up on, to investigate mental health providers regarding Ms. McCandless, is that right?
Yes, sir.
Objection relevance?
Sidebar.
I think the objection's overruled, is that right, Judge?
Objection's overruled. Objection's overruled, however, again,
I understand the limits.
there's some limit.
You did some investigation into mental health providers that Ezra McCandless may have seen, is that right?
Yes.
You went to the Eau Claire County Victim Witness Office, is that right?
Yes.
You spoke with somebody there, is that right?
Yes.
You corroborated that Ms. McCandless had spoke with a victim witness advocate from Eau Claire County, is that right?
Correct.
And that she had been referred to the Bolton Refuge House, is that correct?
Yes, sir.
In the Bolton Refuge House, you're familiar with that?
Yes, I am.
What is it?
It's it's confidential, safe house for victims of abuse, physical and mental abuse.
Fair to say that they provide services for people impacted by domestic violence and sexual assault?
Yes, sir.
You also went and spoke with someone at the Eau Claire Crisis Response Team, is that right?
I don't know if I went and spoke to them. Some of these were phone calls.
I
wanted to
apologize.
speak to somebody on the phone, I believe, on that one.
You spoke with somebody from the Eau Claire Crisis Response Team, is that right?
Yes, sir.
Kristen Wojtowicz?
You did better than I did.
Wojtalewicz, is that right?
That's correct.
Okay. You spoke with that person?
Yes.
Actually, I apologize. I think I may have misled you. I don't want to do that. You spoke with Jeff Wilson, who told you he referred Ezra to the woman whose name I can't pronounce. Is that right?
Correct, that's correct.
Okay. And then as long as we're on, you then contacted Chippewa County District Attorney, correct?
I did.
And Ms. McCandless, you were aware lived in Stanley, is that right?
One of many places, yes.
And Stanley is in Chippewa County, is that right?
Yes.
So you reached out to the Chippewa County to speak with Kristen, because that's where Kristen was now working, who had previously been in the Eau Claire Crisis Response Team, is that right?
Yes.
And then you learned that she had also referred Ms. McCandless to the Bolton Refuge House, is that right?
Correct.
And she'd also referred Ms. McCandless to the Chippewa Falls Family Support Center, correct?
Yes.
And then you eventually contacted the Chippewa Falls Family Support Center, correct?
Yes, with Miss Kara Dorzak.
Okay. And fair to say that they were not willing to, the Chippewa Falls Family Support Center was not willing to share information for you unless you had a release or a warrant, is that right?
Correct.
You certainly know how to obtain a search warrant, is that right?
Objection argumentative.
State.
Have you obtained a search warrant in the past in your career, sir?
Objection, can we have a sidebar?
Did you obtain the records from the Chippewa Falls Family Support Center?
No.
Do you know if anybody from the Dunn County Sheriff's Department has done so since you've left?
Objection relevance.
Just saying. Relevant, but again,
Mr. Nelson, let's
I'm almost
go
done.
through, okay, good.
Are you aware if anybody else has obtained those records?
No.
Those are all the questions I have. Thank you.
Okay, any redirect?
You were asked earlier about your report regarding the defendant's injuries. Do you remember that?
Yes.
Did you actually observe the defendant's injuries yourself?
No.
And you were asked some questions, scrub job, about the Fear and Trembling book.
Correct.
I believe that's exhibit 654. If I could publish the back of it for the jury.
You may.
There we go. Could you please read the back of this book for the jury, please?
Sure. In Fear and Trembling, Kierkegaard, writing under the pseudonym Johannes de Silento, expounds his personal view of religion through a discussion of the scene in Genesis in which Abraham prepares to sacrifice his son at God's command. Believing Abraham's unreserved obedience to the essential leap of faith needed to make a full commitment to his religion, Kierkegaard himself made great sacrifices in order to dedicate his life entirely to his philosophy and to God. The conviction shown in this religious polemic that a man can have an exceptional mission in life informed all Kierkegaard's later writings and was also hugely influential for both Protestant theology and the existentialist movement. Alistair Hannay's introduction elucidates Kierkegaard's philosophy and the ways in which conflict with more accepted contemporary views. This edition also includes detailed notes to complement this groundbreaking analysis of religion and a new chronology. Translated with an introduction by Alistair Hannay.
Thank you. I have no further questions.
Any recross based upon that redirect?
Sure. On the back of the book, there was some talk about the story of Abraham, is that right?
Yes.
Are you familiar with the story of Abraham?
Objection, relevance.
Overruled.
Are you familiar with the story of Abraham and his attempt to sacrifice his son Isaac?
Yes.
There's also some mention on the back of that book about existentialism, is that right?
Correct.
Are you familiar with existentialism?
No.
Okay. That's all, thank you.
Okay, thank you, Officer Chrysos. You may step down.
Mr. Conkey, can you state your full name and spell your last name for the court reporter, please?
Brett Conkey, it's Kohnke.
Thank you. Mr. Conkey, were you in March of 2018 employed with the Dunn County Sheriff's Office?
Yes,
How long were you employed with the Dunn County Sheriff's Office and from what time period?
roughly 16 years, started in March 2002 till May of 18.
May 2018?
Yep.
During the time in March 2018, what was your title?
Narcotics investigator.
Were you a part of the West Central Task Force?
Yes,
Is that a drug task force?
yes.
Do you have any training in death investigations?
I went to the Wisconsin Division of Criminal Investigations 2-week death school.
Do you remember approximately what year, when that was?
I tried checking, I think it was September, October of either 2014 or 15. Don't remember for sure.
You said that's a 2-week school?
Yes,
Is that put on by the Department of Justice?
yes.
Now, in this case, you, in March of 2018, you collected some items from the Eau Claire Police Department. Is that correct?
Yes.
Your Honor, may I approach?
You may.
I'm showing you what's marked as Exhibit 656, which is also DOJ 400. Do you recognize what that item is?
I'm sorry, say that again.
Do you recognize what that item is?
Yes, it's an inventory record for the sheriff's office for when we collect evidence.
I'm sorry, go ahead.
For when we collect evidence.
I'm going to show you exhibit number 553. You see that?
Yep.
Do you recognize what that exhibit is?
That was the sexual assault kit that I obtained from Eau Claire Police Department.
Does that exhibit also, those inventory logs for property as it relates to the items of evidence you received from the Eau Claire Police Department.
Yes.
I'd move both of those exhibits into evidence, please.
Objection?
No, Judge.
All right, Exhibit 656 and Exhibit 553 will be received.
Now, I'll have you look at Exhibit 553. You said there's a blood kit, but it also mentions a SANE kit and victim's clothing, correct?
Correct.
And now if you look at the other exhibit, and I apologize, could you tell me what that number is?
655.
The green one that you have?
The exhibit number?
Yes.
655.
Now, Exhibit 655, that contains more detailed descriptions of items of clothing, is that correct?
Correct.
And what numbers are those, from what to what in the item log?
Item number 28 through 36.
Can you go one by one through each of those and explain what each of those is according to the sheet in front of you?
Item number 28 would be the, essentially the sexual assault kit that is used at the hospital that was collected for any evidence that was collected at the hospital. Item number 29 also would have been obtained at the hospital and would be any blood drawn from
Ezra McCandless?
Ezra McCandless. Item number 30 would be leggings that were obtained from McCandless. 30A,
We have no objection to the publication of this if it's helpful.
Your Honor, may I approach, let's put it on the Elmo.
All right, now, you're talking about the list?
Exhibit 655.
Any objection to 655 coming
No,
in?
I believe it's
Exhibit-
already been received. No objection to publication.
I don't think it was.
I think he said 656 and not 655.
Yeah, 656 was received.
If I did, it should have been 655, Judge.
Is that DOJ 400?
It is, I apologize.
Okay, so 655 will be received, and
We don't have 656.
I refer to 656, we'll just disregard that.
Thank you. Now, we'll just go through Exhibit 655, starting with item number 28. You said that's the forensic evidence collection kit from the Eau Claire Police Department, correct?
that I obtained from them, yes.
And second, item number 29 was the blood kit from the Eau Claire Police Department, correct?
Correct.
Exhibits 30, 30A, or I'm sorry, items 30, 30A, and then 31 through 36 are all physical items of clothing from Ms. McCandless, correct?
Correct.
And those were all items that you collected from the Eau Claire Police Department, right?
Correct.
And what did you do with them when you left the Eau Claire Police Department?
I brought them back to the sheriff's office to be entered into our evidence.
When you recovered them from, or retrieved them from the Eau Claire Police Department, were they all in sealed packaging?
Yes.
Was it your understanding that those were items of clothing that were recovered from the defendant on the day that she was taken to the hospital?
Yes.
So when you got to the Dunn County Sheriff's Office, did you open the items for photographing?
I did, yes, at some point.
Did you photograph the items?
I did.
After you were done photographing the items, were they logged into evidence?
Yes.
While they were open, did you do anything to alter the contents of the items in the bags?
I did not.
And before they were logged into evidence, they were resealed, I assume?
Yes.
So were each of the items in the same condition from the time they were taken out of the bag, photographed, and then put back in and sealed up?
Yes.
As part of this case, did you also transport a number of electronic items from the Dunn County Sheriff's Office to the Chippewa Valley Regional Computer Forensics Lab at the Eau Claire Police Department?
Yes.
And were those items, if you recall, an HP laptop, 2 Samsung cell phones, an Apple iPad, a 32 gigabyte excuse me, SD card and a 4 gigabyte flash drive.
That would sound correct.
And were those items turned over to detective or investigator, I believe it's Detective Chad Stettel?
Yes.
Now, as part of your work as a drug investigator, is it fair to assume you analyzed cell phone data before?
Yes.
And is there a specific process that you utilize in order to extract cell phone data from a phone to either a hard drive or a flash drive?
I used the Celebrite to extract any data and then placed onto a hard drive, or not a hard drive, a flash drive.
And Celebrite is something we've heard a little bit about. Is that a program or a tool that you use to extract that data?
Yes.
Is that something that you're trained in?
I received some training from the chief deputy on it.
Was that prior to your involvement in this case?
Yes.
At the time when you were a narcotics investigator, how regularly were you conducting extractions using Celebrite of cell phones?
It would vary. It could be 1 phone a week. It could be 5 phones a week, just depending on what we have going on.
Do you have a ballpark idea of approximately how many cell phone extractions you completed prior to March of 2018?
I'm going to say somewhere in the range of 40 to 60 phones. Couldn't tell you for sure.
Could you just give the jury a general idea of what that process entails on your end?
You'd hook it up to the Celebrite, and it would ask you to make some various changes to the phone, which would allow it to access the information, so you could draw that information from the phone onto a flash drive. It was typically a matter of changing settings within the phone.
Are there different levels of extractions that produce a different amount of data from a cell phone?
Yes.
And one of those, is that a physical extraction
Yes.
versus a logical extraction?
Yes.
Do you remember having contact with Jason Mengel on March 23rd, 2018?
Yes.
Did you obtain a cell phone from him?
I did.
And was that his cell phone, if you know?
Yes.
Did you conduct a cell phone extraction using the Celebrite tool of that cell phone?
Yes.
And prior to coming to court today, have you had an opportunity to review an item of evidence? And if I may approach, you may. Have you seen this item before?
Yes.
And is that your initials on both the packaging as well as the contained flash drive?
Yes.
And that's Exhibit 262, correct?
Correct.
Is that, based on your review of the information contained on that flash drive, an accurate copy of the cell phone extraction you conducted of Jason Mengel's cell phone around March 23rd of 2018?
Yes.
I'd move Exhibit 262 into evidence.
We approach, Judge?
Subject to limitation, Exhibit 262 will be received. Basically, that it's extraction, it's a copy of the data contained in that cell phone.
Thank you. Nothing further for this witness.
Okay, any cross-examination?
Yes, thank you. You made observations of the clothes Miss McCandless was wearing, is that right?
I'm sorry?
You took photographs of the clothes that Ms. McCandless was wearing on March 22nd, is that right?
Yes.
Judge, I want to talk with this witness about exhibits 639, 640, 619, and 632, all of which would have been previously marked and received.
All right, thank you.
Permission to publish then?
You may.
Showing you what's been marked as showing you what's been marked as Exhibit 639. Does that appear to be the a photo of the T-shirt that you'd collected that Ms. McCandless was wearing on the 22nd of March 2018?
Looks to be yes.
Showing you what's been marked as Exhibit 640. Does that appear to be the blue flannel or the blue button-up shirt that Ms. McCandless was wearing on March 22nd, 2018?
Yes.
Showing you what's been marked as Exhibit 619. Does that appear to be the gold sweater that Ms. McCandless was wearing on March 22nd, 2018?
Yes.
I'm showing you what's been marked as 632. Does that appear to be the white and blue flannel shirt that Ms. McCandless was wearing on March 22nd, 2018?
I believe so, yes.
You, and those, your photos, you took like hundreds of photos of her clothing, is that right?
I don't remember how many I took. But
Lots.
yeah.
Fair to say, on the top half, that was what you documented her clothing was those 4 layers, correct? You took photos of 6 items of clothing, is that right?
I don't remember what I took photos of, or how many I should say.
Okay, how many photos or how many items?
No, how many items, sorry.
Okay. But you agree that
Those look familiar from what I recall.
the 4 items that I just showed you?
Yeah.
Okay. Showing you what's been marked as exhibits 569 and 570. Do you recognize those articles of clothing?
I'm assuming those are the ones I photographed. I don't recall, but
Do you recognize these or not?
not completely, no. I couldn't tell you.
You took a whole series of photos, did you not?
Yes.
Your whole series of photos was documented on DOJ CD RRRR. It's 4 R's. Do these appear to be photos that you took?
Yes.
Would it refresh your memory to look through all of the photos that you took on RRR to see if the 2 items of clothing here?
I can, yes.
Does that refresh your memory, sir?
They look to be the same.
So your memory's been refreshed?
Best it can be.
You would agree that exhibit 569 is a photo of the leggings that Ms. McCandless was wearing on March 22nd, 2018?
Yes.
You would agree that exhibit 570 is a photo of the front of the jeans that Ms. McCandless was wearing on March 22nd, 2018? Agreed?
Yes.
Move for the admission of 569 and 570.
No objection.
Permission to publish.
Exhibits 569 and 570 be received. You may publish.
On the screen there now is exhibit 569, is that correct?
Yes.
And then the next, that's a picture of her leggings, is that right?
Yes.
And then on exhibit 570, that's the picture of her jeans, is that correct?
Correct.
You participated in the search of Mr. Woodworth's apartment, did you not?
Yes.
Did you take the photos that were conducted during that search?
I don't believe I did, no.
Okay. Do you recall the recovery of some books and some journals in that apartment?
I honestly don't remember what was recovered or what I recovered from there.
Okay. There's a couple of books here. Book that's entitled Fear and Trembling by Mr. Kierkegaard. Do you recall seeing that?
I do not.
Okay. know where that was recovered from.
No idea.
Those are the only questions I have. Thank you.
Any redirect?
Very brief. You never actually saw the defendant wearing any of the clothing, correct?
Correct.
You just simply picked it up, it was packaged already from Eau Claire Police Department and took it back?
Correct.
Okay, nothing further.
Who gave it to you?
Eau Claire Police Department,
Do you know where they got it from?
the hospital.
Do you know where the hospital got it from?
From what I was told, Ezra McCandless.
From her body,
Correct.
her corpus? Her body?
Yes.
That's all.
All right, you may step down. Thank you, Mr. Conkey. Is Mr. Conkey free to leave?
Yes.
Okay, you have a good day. Thank you. Thank you.
Can you please state and spell your last name for the record?
Scott McRoberts, McRoberts.
What is your occupation?
I'm a patrol captain right now with the Dunn County Sheriff's Department.
And how long have you been employed in law enforcement?
27 years.
On March 23rd of 2018, do you recall being contacted by Sergeant Rich Day regarding a potential homicide investigation?
I do.
And after you learned of this investigation, what did you do?
I proceeded to the office to lend any assistance I could.
And were you later assigned to perform a neighborhood canvass?
Yes.
And what do you do during a neighborhood canvass?
I was assigned to check the area of 430th Avenue in County E for any potential residents in that area that may have seen anything suspicious the last day and a half, and potentially might have seen a silver Chevy Impala in the area.
And did you obtain any information from any neighbors?
Nothing pertinent, no.
Did you also spend some time looking for any type of surveillance cameras?
Yes.
And what did you do for that?
Throughout that route from 430th Avenue, I traveled County E toward the Eau Claire County line. The only camera I found at that time shooting to the road was at the 24/7 telecom site just in Eau Claire County on County Road E.
And did you learn whether 24/7 telecom had any video surveillance pertinent to this investigation?
Yes.
And what did they tell you?
I met with one of their representatives, and I was advised that their cameras are motion activated. The camera shooting toward County E only captures traffic coming into the driveway when a vehicle would drive into the driveway. It doesn't run 24/7 and capture actual traffic traveling on County E. So we did not have anything that we found related to this case.
The following day, on March 24th of 2018, do you recall searching the ditch lines?
Yes.
And why were you doing that?
Just in the event there was other evidence missed during the evening search, we still had that area, an officer on scene for security during that time, and we just wanted to go back during the daylight to see if we could find any other items.
If I could publish for the jury Exhibit 277, it's in the drone photos, it's already been entered into evidence.
You may. That's already received.
Yes. And if you can utilize that pointer to just visually point out for the jury where you were searching.
Initially, when I arrived, Deputy Feeney was doing a drone flight in this area. Deputy Reed and I, and Deputy Feeney, once he's done with the drone, searched each side of the road here on up through past the vehicle in this general vicinity. At that time, I had placed a phone call to Investigator Conkey, who was doing an interview to see if he had learned anything that would guide our search. And he told me that...
Objection, hearsay. It's going, and can we approach just briefly, Judge? Okay, just approach briefly.
So Sergeant McRoberts, did you receive some information which caused you to change the area in which you were searching?
Well, we finished the area. We finished along the fence line there. Since that was snow covered too, we were looking for tracks. There were no tracks in, no tracks out. So we eliminated this area and then started searching westbound on 430th Avenue along the south ditch.
And as you proceeded up that road, do you know where the Don Sipple residence is? On
Yes.
that? And can you just point that out with the red dot right over around that area? Was there less snow cover as you traveled up that road?
Yes, as you got past that area there.
And was a knife located then near the driveway to Sipple's daughter's residence?
Yes,
And did you observe that knife?
yes.
And what, if anything, did you do?
Deputy Feeney had told me he could see a knife in that location. I messaged Sergeant Kurtzall's a picture of the knife since he was at the autopsy. They requested some measurements, so we provided some estimates on the length, width, type of knife it was without handling the knife.
And was this on, this was on March 24th, 2018?
Yes.
I'm showing you what's been previously marked as Exhibit 283. Have you seen this diagram before?
Yes.
And where the knife was located on this diagram, are you able to identify that for the jury?
Yes.
And where was that?
Should be right nearest the driveway labeled B.
And were some photographs also taken with respect to the knife?
Yes.
I'm showing you what's been marked as exhibits 435 to 441. And are those accurate depictions of the knife as it was located on March 24th, 2018?
Yes.
I'd move exhibits 435 to 441 into evidence.
Any objection?
No, Your Honor.
All right, exhibits 435 through 441 will be received.
Request to publish those on the screen.
You may.
Showing you what's been marked as exhibit 435. What is depicted in this photograph?
A knife.
And is that how you recall it being located on March 24th with the blade pointed up?
Yes.
What's depicted in exhibit 436?
Is this it?
Yes.
The knife as well.
And what is depicted in exhibit 437?
The knife, and you can see the background of the Sipple residence there.
And exhibit 438?
I can see a cone in the background again, the Sipple residence, the driveway leading in.
And do you know if that cone was in relation to where the knife was located?
Can't recall if we placed that. There was a cone left there overnight to mark some foot tracks in the area, and also the back of a cell phone cover that had been located along the roadway.
And exhibit 439, what does this photograph depict?
It gives a view back down toward the dirt road and looking east from where the knife was located.
And it appears that there's some potentially cars and people standing down, further down in the picture. Do you see that?
Correct. Yes.
Is that where the entrance to the field drive is?
Yes.
Exhibit 440, what's depicted in this photograph?
Yeah. In the very forefront, you can see the knife, and in the background again, that view east to that field driveway.
And then exhibit 441,
That's a measurement of the knife blade.
May I, Coach Turner?
You may.
I'm showing you what's been previously marked as Exhibit 233. What is that item?
It is a folding knife.
And is it the same knife that you recall seeing on March 24th, 2018?
Yes,
That was in the ditch line?
correct.
I'd move Exhibit 233 into evidence.
Any objection?
No, Judge.
Exhibit 233 will be received.
And then I'd request to publish that to the jury if you wouldn't mind walking down and showing that to the jury.
You may, go ahead.
3 days later, after the knife was located on March 27th of 2018, do you recall executing a search warrant on the defendant for her DNA?
Yes,
And is the same person you obtained DNA from present in the courtroom today?
yes, she is.
Could you describe what she's wearing and where she's seated for the court?
She's sitting at the defense table in the middle, wearing a black coat and glasses.
Record will reflect the witness has identified Ms. McCandless, the defendant.
And what did you, or how did you obtain the DNA sample from the defendant on March 27th?
Well, there's two different things we did with the search warrant. We obtained buccal swabs, which are cotton swabs used to swab the interior cheek area of the mouth. And also we pulled hair samples from the head hair.
And what, if anything, were you wearing to ensure your DNA was not contaminating the samples?
While doing the buccals, I had rubber gloves on and just swabbed the interior of the mouth, placed those swabs into evidence bags. And then on the hair pulls, I wore a dust mask as well, just to eliminate any possibility of breathing onto Ms. McCandless while I proceeded to pluck the hairs.
And what did you do with the samples once you were done collecting them?
Both samples returned over to Sergeant Day eventually for transmittal to the crime lab.
That same day, do you recall walking the ditch line again to try to locate Alex Woodworth's cell phone?
Yes,
And were you able to locate his cell phone?
no,
But while you were there, do you recall speaking with a man named Chester Davidson?
yes.
And what was that conversation regarding?
It was regarding a trip, one trip he had made through there. He had indicated he thought it was on the Friday, which would have been the 23rd, initially is what he thought. He was traveling to work and saw a small sedan parked blocking the eastbound lane at that field drive, and he had to go out around it. After having further conversation, he realized it was actually on the 22nd.
And did he show you his work schedule to confirm that it was actually March 22nd that he saw that vehicle?
Yes, he did.
And was your conversation with Mr. Davidson audio or visually recorded?
No,
And why not?
I obtained a written statement from him on scene.
And were you planning on performing any interviews while you were out searching the ditch line?
No,
And then on March 29th of 2019, 7 days after the date in question in this case, did you search the ditch line again for Alex's phone?
yes,
And were you finally able to locate his phone?
yes.
I'm showing you what's been marked as Exhibit 283 again. Are you able to determine with the letter marking where the cell phone was located?
It would be just under the 430th Avenue portion labeled C. Yes.
And what, if anything, did you do with the cell phone when you located it?
I actually placed a phone call to Alex's father. He had initially told us Alex had a Nokia phone, and I could see this was an LG, and after speaking with John, he actually had the records indicating it would have been an LG cell phone, and he provided me with the IMEI number, which would identify that phone, and that is the number that I found on the phone.
And did you take photographs of the cell phone as you locate it?
Yes.
I'm showing you it's been marked as exhibits 503 through 508. And do you recognize those photographs?
Yes.
And do they accurately depict the cell phone as you located it on March 29th, 2019?
Yes.
Move exhibits 503 to 508 into evidence.
Any objection?
No objection.
All right, exhibits 503 to 508 will be received.
And I'd request to publish on my screen those photographs.
You may.
And what do you see in exhibit 503?
I can see the cell phone right here.
And exhibit 504?
Again, a close-up of the cell phone and the battery that was dislodged from the phone.
And what does exhibit 505 depict?
An overview of what that ditch line looked like and the grass that's matted down indicating there was flowing water at one point.
And 506?
The phone, the battery, and again, the strands of grass, and again, directionally laid down to the east where that water was flowing in the ditch.
What is exhibit 507?
It's a close-up of the ID here, identifying that phone.
In exhibit 508?
A picture of the face of the phone showing some damage.
And did you also place the phone in some rice?
We did,
Why did you do that?
to try to extract any existing moisture that might have been in the phone, hoping that we would be able to download and get the information off the phone.
Thank you. I'm showing you what's been marked as exhibit 235. What is that item?
Is that just 35?
235.
235.
It does appear to be an LG cell phone.
And does it appear that it's changed condition since the last time you've seen it?
Yes.
State would move exhibit 235 into evidence.
Any objection?
No, Your Honor.
Exhibit 235 will be received.
Also, as part of this investigation, did your office execute a warrant for an Instagram account belonging to the defendant?
Yes.
And what was the name of the Instagram account associated with
Objection
it?
to the approach.
And was the name of the Instagram account associated with the defendant?
Yes.
All right, I just, I guess this is for court TV. Please, if you would just block out the title for purposes of broadcast, so we don't have I think there's a delay, so we'd ask that not be broadcast. Thank you.
Captain Fragrance, I'm showing you what's been marked as exhibit 267. What is that document?
It's a certificate of authenticity of domestic records of regularly conducted activity at Instagram.
And is it related to the defendant's Instagram account?
Yes.
I'd move exhibit 267 into evidence.
Any objection?
No objection.
Okay, and subject to the limitation discussed, exhibit 267 will be received.
May I approach again?
You may.
I'm showing you what's been marked as Exhibit 268. Do you recognize that disc?
Yeah, it's a DVD with the Instagram download.
And are those your initials on the disc?
Yes,
And did you have an opportunity to review the contents of that disc sleeve to ensure they're accurate?
yes,
And based on your review, is that an accurate copy of the Instagram account associated with the defendant?
yes.
I'd move Exhibit 268 into evidence.
Same objections requesting the limitations previously discussed.
Okay, Exhibit 268 will be received for what it is, but not necessarily for the contents thereof. That would be a later issue, but the fact that it's a download of that data, it'll be received for that purpose.
I have no further questions.
Okay, cross-examination.
Thank you. Mr. McRoberts, I want to ask you some questions about March 27th when you were out searching the ditch line, okay?
Sure.
When you were out doing that, as you said, you were not planning on interviewing witnesses, citizens, or otherwise, correct?
Yes,
When you plan to do an interview, you bring certain equipment to aid you with that, is that right?
if it's planned, yes.
And if it's planned, you'd bring something to record it, is that correct?
Correct.
Because, as you know, the human memory isn't always perfect, so you try to make sure that it's accurately documented by getting a digital recording of what people say, is that right?
In many instances, yes.
Yeah. And so that's the best practice, agreed?
Sure.
On that day, because that wasn't your intention, you didn't have a digital recorder with you, agreed?
My squad car was there. I could have activated that at some point. I just went with the written statement.
And so your intention is still to make sure that you accurately record everything that's told you, correct?
Correct.
There's just different ways of you recording that, right?
Yes.
Sometimes you record it again with a digital recorder. Yes?
Yes.
Sometimes you have the person write out a written statement in their own words, agreed?
Correct.
And in addition to that, you also make a summary report of what you heard, is that right?
Yes.
And so you did that in this case, you wanted to make sure that you wrote down what it is that you heard, agreed?
Yes.
When you wrote all that down, you knew, hey, I don't have the reporter that I normally have, so I want to make sure I get this down all correct. Is that right?
Yes.
And so you wrote out a report about what Chester Davidson told you, is that right?
Yes.
And what Chester Davidson told you, just so we can put this into context, Chester Davidson was the bus driver going to work who said he saw a car at the entryway to this muddy road, is that right?
Yes.
And what Chester Davidson told you is, as you put in your report, he couldn't recall who was driving. Agreed?
Yes.
Those are the words that he told you on that day, right?
Yes.
You also helped in the search of Alex's apartment, is that right?
I was there, yes.
Were you the one, somebody took photographs, were you the one that took photographs?
No, I did not.
Do you recall the collection of the evidence that was there?
I didn't deal with the actual collection or logging of any of the evidence, so I don't have much of a recollection of that portion.
Okay, there's a book over, there's several books over here, but one of the books that I believe is been marked as Exhibit 654. Did you collect that book called Fear and Loathing by Soren Kierkegaard?
I do not recall collecting that.
Okay, you don't know where that was found?
No, I don't.
Okay. On the 27th, you executed a search warrant in which you obtained samples from Ms. McCandless, is that correct?
Yes.
You collected her DNA, is that right?
Yes.
You also collected her hair, is that right?
Yes.
Do you know why it was that you were asked to collect her hair?
Well, I recall there was hair in the, I think, floor area of the back seat of the, or back passenger compartment of the vehicle, so we wanted to make a comparison of that.
The hair that was found with the hair that was actually with Ms. McCandless on her head still, right?
Yes.
All right, so you collected some of that, right?
Correct.
And then you took that hair and you did what you did with the rest of the collections. You eventually put it in the process where it would get sent to the crime lab, right?
Yes.
The items that you recovered, I want to talk to you about that just briefly, okay? The Exhibit 283, there's three items here listed, EA, EB, and EC, is that correct?
Yes,
And the E is for evidence, is that right?
I believe so.
And the A is simply another way to write down the value of them, whether it's, or not the value, to document. Instead of 1, 2, 3, sometimes you just use letters, is that right?
Yes,
And on this, was it you that chose the labeling of them as A, B, or C, or did somebody else do that?
somebody else did that.
Evidence, you'd said the knife is EB, is that right?
That's correct.
Was that found the same day that EA was found?
No,
Do you know what EA is?
that's the back of the cell phone.
Okay. And you know what EC is, the front of the cell phone?
Cell phone and the battery, yes.
Okay, so EC and EA essentially go together, right?
I never fit them together, but I think they do go together.
Okay. They're different parts of the same phone as far as you know, correct?
Yes,
And EC, you said you found that essentially in the ditch line in an area that to you looked like it had been underwater, right?
well, it had been underwater previous days.
Sure. You'd been there on previous days,
Correct.
and you'd seen that there was water flowing in that area.
Yes,
And then afterwards, you saw, like you showed in the picture, the grass was matted down, showing that the water was flowing in a certain direction, right?
yes,
Were you there the day when there was I believe there was a dog out there assisting in the search as well, is that right?
I was not out there then.
You weren't there then. But the item EC, the phone, was in a position where just days before it was under flowing water, correct?
Water or even snow, I can't recall exactly in that location how much snow would have been left.
So at some point it may have been in a snow form, correct?
Yes,
And then if it melted, it was then in a water form, right?
yes,
And then it all melted away and ran off, and so then the phone was left to be there in the ditch, right?
yes,
Right along near the roadway, correct?
yes,
And it was, for lack of a better term, broken, right?
it was cracked on the screen and the battery was laying out of it. Yes,
And there was a whole nother piece that was missing from that position, right?
yes,
And do you know how that piece became broken off?
no,
The phone itself, EC, when you saw it, it did not appear to have any blood on it, right?
correct. I did not note any blood.
And if you had, you'd have probably sent it to the crime lab if you'd seen something like that, correct?
Yes,
But because you didn't see any of that, you didn't send it to the crime lab, correct?
yes,
And I would imagine that probably didn't surprise you since it had been in flowing water for a number of days, correct?
yes.
Those are the only questions I have. Thank you.
Any redirect?
Just very briefly, so the cell phone, was it located in flowing water before, or was it in a snowbank? Or don't you recall?
The day I found it?
The day before? I mean, because you searched that area before, right?
Yeah, the actual day before. I was there on the 27th. I was not there on the 28th, as I recall, and then found it on the 29th. So I can't recall how much snow was left right at that area of the shoulder going into the ditch when I was there on the 27th to compare it.
So it's possible it was under a pile of snow? Is that right?
Yeah, it could have been washed under that snowbank, and that melted away and finally exposed it.
Sure. And how rapid was the water flowing? I mean, if you can describe any,
I recall a constant flow of water across that field drive because
That-
that's the direction it was going. All the water was heading down that way. And,
along the ditch line or just along that entrance to the field drive?
well, from where there was snowpack yet, it was wherever the snow was melting, it was contributing to that flow. And where the cell phone was found at sea was certainly down farther than these other items that were found. And that area had more snow in the ditch
In what direction was the water flowing?
to the east.
No further questions.
Any redirect?
Yes, please. I want to talk to you about exhibits 503, 04, 05, and 06, okay? I'm going to put them on the Elmo, but if you think it helps for you to look at them in person, just let me know, okay?
He's already received.
Yes.
They're here, correct?
So exhibit 503, is that up on the screen? You see that?
Yes.
And the phone, if I'm correct, is that it there?
Yes.
Okay. And the bottom of the picture, would that be the west side?
Yes.
And the top would be the east side?
Correct.
So as far, what you're saying is in this way, if the water's flowing from the bottom of the picture to the top of the picture,
Yes.
and it would be flowing, if the phone is in that position, the water's flowing over the top of that phone, correct?
Yes.
That was based upon your experience being there 2 days before. That phone there would have been under flowing water, correct?
Yes.
And as you said, I believe it was constantly flowing water, agreed?
Yes, at that time.
And by that time, you mean for a period of several days?
Well, it's not flowing overnight. When the temperatures get back down to freezing, it's going to stop flowing as the melt curtails. So then as the temperature warms again, it'll start flowing again.
And so whether it was a constant 24-hour period, it was under flowing water for certain periods over several days, agreed?
Yes.
All right, thank you.
Okay, I believe that Captain McRoberts is all we have for you.
Can you please state and spell your last name for the record?
Josh Christensen. Christensen is spelled Christenson.
What is your occupation?
I'm a patrol sergeant for the Dunn County Sheriff's Office.
How long have you been a sworn law enforcement officer?
About 18 years.
On March 23rd of 2018, do you recall being dispatched to the area of County Highway E and 430th Avenue?
I do.
And why were you dispatched there?
Eau Claire Police Department had located a deceased male in our county and asked that we respond to the area.
And was anyone else with you when you arrived?
I had trainee Deputy Porter with me, whom I was field training at the time, and I met at the scene with Investigator Piper from Eau Claire and Sergeant Dave from our office.
And what, if anything, did you do when you arrived with respect to scene security?
Upon arrival, we just made sure that no one else went in there after we got there, while we decided what we were going to do from there.
And was a crime scene entry log sheet created?
Yes, it was.
May I approach?
You may.
I'm showing you what's been marked as Exhibit 442. Do you recognize that document?
Yes, I do.
And what is it?
It's a crime scene entry log.
And it's, how many pages is it?
3.
And looking at Exhibit 442, can you determine approximately what time Katie Hoffmeyer from the Wisconsin Department of Justice, when she arrived?
It indicates that she entered the scene at 1954 hours.
On March 23rd of 2018?
Yes.
And was the scene secured until the evening of March 24th, 2018?
Yes.
I'd move Exhibit 442 into evidence.
Any objection?
No, Judge.
Exhibit 442 will be received. Is that the right number?
Yes.
That'll be received.
On March 24th of 2018, do you recall returning back to the area of 430th Avenue to photograph some additional evidence?
Yes, I do.
May I approach, Your Honor?
You may.
I'm showing you what's been marked as exhibits 451 and 452. Do you recognize those photographs?
Yes.
And are they, what's depicted in the photographs?
Is the back of a LG cell phone and its location.
And what, if anything, did you do when you arrived out to the scene?
I was requested to respond there to photograph and collect the items as evidence. So upon arrival, I did that. I photographed the marked exhibits and collected them to the proper procedures and later took them to our evidence locker at our sheriff's office.
And are these accurate copies of the photographs, do you remember?
Yes.
I move exhibits 451 and 452 into evidence.
Any objection?
No, Judge.
All right, exhibits 451 and 452 will be received.
Request to publish those exhibits on my computer.
You may.
Officer, what is depicted in exhibit 451?
That is 430th Avenue, and we are facing west. There's some traffic cones there. In the front portion of the photo is where the back of the cell phone was located.
And what's depicted in exhibit 452?
That would be a close-up of said cell phone back with a evidence tag associated with it.
Thank you. Deputy, I'm showing you what's been previously marked as exhibit 283. Looking at this diagram, are you able to determine what evidence marker was associated with the cell phone back that was located?
Yes, that would be E/A on the diagram.
Thank you. Then I'm also going to show you. Thank you. What's been marked as exhibit 234. Do you recognize that item?
I do.
And what is it?
This is the item I collected at scene, which is also the item that is in the photographs.
And that's the same cell phone backing for an LG?
It is.
I move exhibit 235?
234, is it?
Does it say 234 on there?
234.
Sorry, thank you. 234 in evidence.
Any objection?
No, Judge.
Okay, exhibit 234 will be received.
I have no further questions.
All right, Mr. Nelson, are you doing cross? Go ahead.
Yes, please. Sir, I want to ask you some questions about exhibit 451. Actually, can you, that's the photo we see up on the screen, is that right?
Yes.
You were the one that recovered the back of the cell phone?
Yes.
Prior to your recovering it, I think, were you the one that wrote down about the kids riding their bikes in the area?
That was not me, no.
Okay, but you remember the kids riding the bikes in the area?
I don't know anything about that.
You didn't make any observations of children riding bikes in the area?
Not when I was there, no.
You didn't talk to anybody else about kids riding over the back of that cell phone?
No, sir.
And do you recall making an observation of a bicycle track in the dirt that rides over the cell phone and appears to skid out right there at the end of it? Do you see that in the picture?
I do see that, yes.
Does it appear to be a bike track starting at the cone here and then going would this be in a westerly direction? The top of the photo is to the west, is that right?
Correct.
The bottom of the photo is to the east?
Yes.
And so it's, as he comes towards us, it's going in an easterly direction, correct?
Yes.
And so does it appear to be a track from a bicycle coming from the west, entering at that cone and going onto the dirt and driving over the top of that cell phone?
Objection. Speculative opinion.
I'm sustained, unless he knows, I don't want him to speculate.
Does there appear to be a track there in the dirt?
There does, yes, appear to be a track in the dirt.
You don't know how that track was caused, correct?
Correct.
But you do see the track that I'm referring to, agreed?
I do.
And it appears to take, you follow the track, it goes over the top of the cell phone, agreed?
That seems likely, yes.
And that, in this area that I'm pointing out here at the bottom of the photo, there appears to be a thicker portion of the track, correct?
Yes.
And the track takes an abrupt turn from the previous direction that it was going in before, is that right?
Yes.
And the cell phone back cover that you have there, that's actually cracked, isn't it?
I know it had some dirt on it. I don't recall it being cracked.
Okay. You had earlier been at the scene of where the vehicle was, is that right?
Yes.
You took lots of photos of the scene where the car and the trailer were, is that right?
Yes.
And you'd made out a report about that, is that correct?
Yes.
And you recall, now do you recall seeing, do you know where the car was in relation to the other pieces of evidence? Do you have a memory of that?
I do.
Showing you what's been marked as exhibit number 285, does that appear to be a photo of the car next to the trailer as you recall it?
Yes.
All right, and so just roughly, I know there's all these other evidence pieces, do you know what E1 or E3 or 7 or 8 or the other numbers those stand for?
I do not.
Okay, and so I'm not gonna ask you about those, I just wanna ask you about the vehicle.
Okay.
As I hold up here, 285, the top of this is to the north, is that right?
Yes.
The bottom would be to the south, is that correct?
Yes.
You made observations of blood in the grass between the car and the trailer, is that right?
Correct.
You made observations of blood in the grass to the south of the front door, is that right? As well as to the north of the front door.
I don't know exactly where those blood spots were that I noticed when I was in there. I just know they were in between the car and the trailer.
Okay, but in relation, on this photo, you wouldn't be able to say where they were in relation to the trailer in the north-south vicinity?
No, sir.
Okay. And same with any markings on the trailer, you wouldn't be able to tell us where those would be? You don't have a memory of that in particular, do you?
No, sir.
Those are the questions I had, thank you.
Any redirect?
No.
All right, thank you, Deputy Christensen, you can step down. And is Deputy Christensen going to be reserved to recall, or is he free to go?
I apologize, Judge, it's too late for me to ask him 2 more questions.
You moving to reopen cross?
Yes, please.
All right, I'll reopen cross for 2 more questions.
Thank you. You also made observations there between the car and the trailer of multiple shoe or foot impressions, is that right?
Yes.
And you'd said that was between the open door and the trailer.
Yes.
True? That's all, thank you.
Any redirect based on those questions?
No.
Field Services Sergeant for the Dunn County Sheriff's Office.
And how long have you been employed in law enforcement?
Approximately 18 years.
On the evening of March 23rd of 2018, do you recall being contacted related to a body being discovered in Dunn County?
Yes, I was contacted by Sergeant Day.
And what, if anything, were you assigned to do that day?
Initially to pick up scene lighting from the Sheriff's Office, and then we ended up having a briefing at the Sheriff's Office prior to going to the scene.
And what did you do with that scene lighting equipment?
Transported it down to the scene and dropped it off on the roadway area by the other squad cars.
Then what did you do?
I then went and did a canvass of the area looking at parking lots and parks and DNR parking lots along the way that potentially someone could have stopped at. I was looking to see if anything was discarded along the way between Eau Claire and the scene.
And do you recall contacting a church located near County Highway E?
Yes, I contacted the pastor of the Amy Chapel Church and spoke to him about any vehicles that were in the parking lot, or if he had noticed anything out of the ordinary in the parking lot, or if there was any cameras facing towards County Highway E, and he told me that there was not.
And then, did you check a DNR parking lot near County Highway E?
Yes, I did.
And what did you determine when you looked at that parking lot?
That it was completely snow covered, or it was a large drift. There was one vehicle track that had backed in, but there was no evidence discarded. I got out and walked. There was no footprints past where that vehicle was parked.
And did you also check the Elk Lake Tavern?
I did. I pulled into the parking lot and I ended up speaking to one of our deputies who was familiar with the business and said that they did not have any cameras that faced towards the roadway.
After you checked for cameras, did you search the ditches next to the field drive entrance?
Yes, I returned to the location and I checked along with Investigator Stalker and Sergeant Day the ditches. I mainly concentrated on the north side of the road leading from the field driveway up to the Sipple residence.
And did you locate anything?
I did not initially until I was, my attention was drawn to a cell phone case that was on the south side of the road. When we were looking at that location, I noticed some footprints there that appeared to be barefoot or stocking foot. It was hard to tell. It looked like somebody was dragging their feet.
And what, did you do anything else at the crime scene related to the body?
When the medical examiner took custody of the body, I followed them directly behind their vehicle to Olson's funeral home and escorted the body into the funeral home, and it was secured into the cooler and locked, and I took pictures of that lock. The body was never opened. It had a tab on it with the name on it on the body bag.
On March 25th of 2018, did you learn that the cell phone belonging to Alex Woodworth was missing?
Yes, I did.
And what did you do in an attempt to try to locate that phone?
I contacted Chief Derek Vold of the Independence Police Department because I knew that his canine was trained in article searches and requested his assistance, and he responded with his canine by the name of Crush, and we did an article search through that area.
And so did you check near where the trailer was located, or were you searching the ditches along the roadway?
We initially did the area of where the trailer was located and the trail going back to that location. There was one area of interest there where the dog had showed some interest. I checked that area and didn't locate anything. We later checked that with a metal detector and didn't locate anything either. Then we checked the ditch line between the field driveway and the Sipple residence. At that time, the water was probably 3 to 4 inches deep and running rapidly through there, and there was a lot of snow cover yet. Nothing was located at that time.
Then on March 27th of 2018, do you recall meeting with a Jason Mengel?
Yes, I do.
And was another investigator, Rod Dykes, with you at the time?
Yes.
And when you met with Mr. Mengel, did he agree to have his DNA taken?
Yes, he did.
And did you observe a buccal swab being taken of Mr. Mengel's person?
Yes, I observed Investigator Dykes take those swabs.
And what was done with the swabs after they were taken?
They were secured into evidence packaging, and then Investigator Dykes transported them back to the sheriff's office when we were done.
The next day, on March 28th of 2018, did you drive from the field drive entrance where the body was located to Alex's house in Eau Claire, located at 511 Cameron Street?
Yes, we did.
And what route of travel did you take?
We took the 430th Avenue to County Highway E to Cameron Street to the residence.
And do you recall how long it took you?
approximately 17 minutes.
And that same day, did you meet with a Jeremy Kachmer, Kachmar, at Racy's Coffee Shop?
Yes, he was the owner of Racy's at that time.
Why did you meet with him?
To obtain video surveillance of the business during the date of March 22nd.
And were you then provided with video surveillance from the date of March 22nd, 2018?
Yes, it was digital, so they downloaded it onto a thumb drive.
And did you learn that the time and date on the videos was incorrect?
Yes, it's approximately 21 hours off.
So if the date shows March 23rd, 2018, I guess what time would it be on March 22nd of 2018? If it was like March 23rd at 1 o'clock? Would it be March 22nd at 4 o'clock?
Yes.
May I approach?
You may.
I'm showing you what's been marked as Exhibit 153. Do you recognize that disc?
Yes, I do.
And what is it?
It is a disc of the video from the Racy's.
And does that disc, did you review it before coming into court today?
Yes, I did, and I placed my initials on the front.
So it's an accurate copy of the video surveillance you were provided from Jeremy Kachmer from Racy Coffee Shop?
Yes, it is.
Move Exhibit 153 into evidence.
Is that 153 or 453?
I think it's 153.
153 is what it says on here.
Any objection to 153?
No, Judge.
Okay, 153 will be received.
May I approach?
You may.
Showing you now what's been marked as Exhibit 154. Do you recognize that disc?
Yes, I do. It's a short segment out of the original video.
And did you have an opportunity to review it before coming into court today?
Yes, I did. I also placed my initials on that one.
And is it an accurate copy of that, a segment from the counter view from 10:54 to 10:59 a.m.?
Yes, that's correct.
And do you recall briefly what you remember seeing when you viewed that disc?
That was at the time that Ezra came into the business, went up to the counter, made an order, and then she went to the back of the business, and then shortly thereafter tapped Max on the shoulder, and they left the business.
I'd move Exhibit 154 into evidence.
Any objection to 154?
No, Judge.
Right, 154 will be received.
And officer, is there a black device there that you can use a red button or a button to get a red
Yes.
pointer on? I might ask you to use that while I play Exhibit 154, if I have permission from the court.
You may go ahead.
Thank you. Okay, so I have it up now. And I have it paused at 7:54:33. Are you able to use your red dot to indicate if on this video surveillance you were able to identify the defendant?
I would have to have you play it a little bit so I could actually see people moving. Yes, you can stop it there. Right there is the defendant.
Okay. There's no audio, so I'm going to ask you some questions. Sitting at the coffee bar to the left, the hand on the coffee cup, do you know who that is?
Without being able to watch a longer segment of their movements, I would have difficulty saying for sure who that one is.
Are you able to determine who the subject in the bottom left corner is who sat down?
That subject right there is Jason Mangle.
And do you know who the person is sitting to the, I guess on his left?
That would be Max.
Max Martinson?
Yes.
Okay. Now I'd like to show you what's been marked as Exhibit 155. Do you recognize that disc?
I do.
And what is it?
It is the front door view of the same segment that we just watched.
So is that the same time from 10:54 to 10:59?
Yes, it is.
And is it an accurate copy of the video you recall reviewing?
Yes, it has my initials on it.
And was there anything you were able to do to try to improve the clarity of these videos?
No.
I'd move Exhibit 155 into evidence,
Right, Exhibit 155 will be received.
and I'd request to publish that as well for the jury.
Right, you may.
And is that the defendant that you observed just walking in the video?
Yes, it is.
Officer, when you went to Racy's, were you able to observe, was there much more to the coffee shop, or is this pretty much it?
It's a restaurant and coffee shop. At the coffee shop, this is pretty much encompasses the whole area. The only area you can't see is right below this camera is the bathrooms.
And that person that just got up and is sitting down, do you know who that is?
You're talking this individual right here?
Yes.
That's Jason Mingle.
And who's that walking towards the camera?
This one right here is the defendant.
And during that entire time, both Exhibit 154 and Exhibit 155, did you observe the defendant speak to Jason Mingle while inside Racy's?
It did not appear that they spoke.
May I approach?
May.
I'm showing you it's been marked as Exhibit 157. What is that disc?
That is a short segment of the original one showing approximately 11:14 to 11:15.
Is that approximately 15 minutes later than the previous disc we just watched?
Yes,
And did you review that before coming into court today?
I did, and
Is it-
that's my initials on the bottom.
And is it accurate?
Yes, it is.
I'd move Exhibit 157.
Any objection?
No, Judge.
I request to publish that short video for the jury.
You may.
And who do you observe entering the building?
That's Max, and the one that was directly behind him is the defendant.
Is it approximately 11:15 the defendant leaves?
Yes, it is.
Okay, thank you. And Sergeant Mayer, did you review Exhibit 153, the video surveillance from March 22nd, 2018 in its entirety?
Yes, I did.
And during that review, were there any other times you located the defendant on surveillance cameras at Lacy's on March 22nd, 2018, except for those 2 clips that we played today?
No, I did not.
Were you able to locate Alexander Woodworth on any of the surveillance cameras on March 22nd, 2018 at Lacy's?
No, I did not.
Were you able to locate Jason Mingle on the surveillance camera at any other time on March 22nd, 2018?
Yes, I did.
Can you explain for the jury what other times you saw Mr. Mingle at Lacy's coffee shop that day?
I know he was in there at approximately 1:14 p.m., I believe 2:12 p.m. He was in there for a little while that time. And then he was in there again, I believe it was 3:18, but I'd have to refresh my memory to know for sure if that's correct.
So essentially 1:14, 2:12, and 3:18 that day.
Yes.
And were you able to determine Jason Mingle's whereabouts during the afternoon of March 22nd, 2018?
Yes, he was on various different cameras at different businesses and had been taking pictures with his phone during the day that we later recovered off of his phone, and I was able to verify the locations of those pictures.
And those locations were all in Eau Claire?
Yes, one being at Lacy's in the bathroom, another one being behind the joint bar on Water Street.
And did you learn if Mr. Mingle had a car or any other mode of transportation?
He had a car, however, it was disabled. I think it was last registered in 2015, and when we looked at the vehicle, it was packed full of material. He was using it as a storage area, and the tires, 3 of the tires were flat. 3 of the tires were flat, and at least one of them was cracked to the point where it likely was not going to hold air at all because it was a very visible crack in the side of the tire.
And why were you looking into Mr. Mingle's whereabouts on March 22nd, 2018?
To determine if he could have been at the scene as well.
And what was your conclusion?
That he was accounted for in Eau Claire.
Did you also review some video from the Eau Claire County Courthouse?
I did.
And were you able to determine when Mr. Mingle was at the Eau Claire County Courthouse?
Yes, I believe he arrived there right around 5:14 or 5:15 p.m. and was there for a significant amount of time while he was speaking to a City of Eau Claire police officer.
After you received the surveillance video from Lacy's, did you attempt to look for more surveillance videos on the route back from Eau Claire to Menominee?
We did. The City of Eau Claire Police Department had done a video canvas of the City of Eau Claire, so we expanded and went the rest of the route along County Highway E. I located one residence that I could see had visible cameras, and I made contact with the owner there after several attempts, and they advised me that they were just fake cameras to give the appearance that they had cameras. I also located one shed that faces County Highway E in Dunn County that had cameras, and the individual that owned that told me that those cameras only operated when he was there with the generator running.
And does Dunn County have any public recording devices similar to Eau Claire's milestone cameras?
There are none along County Highway E.
On February 1st of 2019, do you recall photographing the defendant's clothes along with Sergeant Jason Stalker?
Yes, I do.
And was one of the items that you photographed a necklace and bracelet?
Yes, it was.
And do you know where it was recovered from?
That was brought to our agency by Investigator Conkey, and he obtained it from the Eau Claire Police Department.
May I approach, Reiner?
Mayor?
I'm showing you what's been marked as exhibit number 500. Do you recognize that item?
Yes, I do. It's the package that contains the necklace and the leather bracelet.
And if you could put on some gloves and open that. Do we have a scissors in there?
There's one up here.
Okay. And if you can just open it and not pull out the contents, just look at it while it's still in the bag. And is that the necklace and bracelet that you recover photographing on February 1st, 2019?
Yes, that is the ones that we photographed.
I'd move Exhibit 500 into evidence.
Any objection?
No, Judge.
Exhibit 500 will be received.
And Sergeant, if you wouldn't mind bringing that down to the table. And if you could publish those items for the jury. Oh, Your Honor, permission to publish?
Go ahead.
Thank you.
Identify your check.
Sure, yes, please.
This is the leather bracelet that we photographed.
And do the buckles appear to still work on that item?
Yes, they do.
Okay, thank you. And what is the other item in that bag?
It is the necklace that we photographed on that date.
And does the clasp appear to be in working condition?
Yes, it's still solid. It's not broken.
Okay, thank you. That's all I need.
Keep the items on.
Also would like to show you, it's been previously marked as Exhibit 639. Do you recognize examining that item when you took photographs on February 1st, 2019?
Yes, that was a T-shirt that we also took photographs of.
I request to publish 639 for the jury.
You may.
Sergeant, when you examined this shirt, do you recall noticing, what were your observations of the shirt?
There was what appears to be a slight slit in the shirt, and then there was a couple of spots on the shirt, but without reviewing. There was a couple of spots on the shirt, but without reviewing my report on that, I would have to see my report to
Sure.
refresh.
If I showed you your report, DOJ 3930, written from February 1st, 2019, would that refresh your recollection?
Yes, sir.
Does that refresh your recollection?
Yes, it does.
And So what were your observations when you examined the yellow tiger shirt?
That the shirt was quite dirty. There was a spot that appeared to be dirt on it right about where the tiger is. Right in this area. And then there was a couple other spots of an unknown substance. I couldn't determine what it was by looking at it, both on the front and then one on the back of the collar.
Okay, thank you. I'm done with the exhibit. And then later on February 25th of 2019, do you recall picking up some electronic evidence from the Chippewa Valley Regional Forensic Lab?
Yes, I do.
Was one of the items a Samsung tablet with a pink cover?
I don't recall that I could see it in its packaging, but it was item number 42, which was described as a tablet.
And did you alter the contents of any of the items you picked up in any way?
No, I picked it up. I did not open the package. I drove it back to the sheriff's office and placed it into temporary evidence storage.
Were you also asked to review a download from a Memorex flash drive that was determined to belong to the defendant?
Yes, I was.
And was there anything of evidentiary value on that?
No, it was all pictures prior to the date of the incident.
Were you also asked to review the contents of an SD card that belonged to the defendant?
Yes, I was.
And was there anything of evidentiary value on that SD card?
It was all also content prior to the date of the incident.
I have no further questions.
Great. Any cross, Mr. Nelson?
Yes, Judge. Mr. Mayor, you executed a search warrant at Jolee Carlin's house, did you not?
I was not present for that.
You weren't there. Was that, you familiar with the investigation?
Yes, I am familiar with the investigation.
Was it Jason Stalker, who was one of the members that did that?
Yes.
Okay. You've both taken a lot of photos. You took a bunch of photos, he took a lot of photos, fair to say?
I don't think I took hardly any photos during this. I assisted him in laying out the items so he could take photos, but I don't believe I took hardly any during this.
So the photos of the search warrant at Jolee Carlin's, that's by Jason Stalker?
It's not by me. I don't know which one took them for sure.
That's fair, okay. Want to ask you some questions about the scene along 430th Avenue, okay?
Yep.
You were there on a day when there was a dog there, right?
Yes.
What day was that?
That was on Sunday the 25th.
Sunday the 25th?
Yes.
And on Sunday the 25th, the water was flowing along the south side of the ditch from Mr. Sippel's residence, roughly the driveway there, down towards the entrance to the field drive, correct?
Yes, it was draining out of the field and from his driveway along that ditch line.
And it was a continuous flow, at least during the day when the temperatures were warm enough?
Yes.
And the water was, I think you said at least 4 inches deep?
3 to 4 is what I estimated. I didn't measure it.
And it was flowing?
It was flowing, yes.
And at some point, the dog, did you say it was Crunch?
Crush.
Crush. The dog Crush had alerted on something in the water in the south ditch, is that right?
All the way down at the end by the driveway, the field, or the driveway back to this location.
In the area near the entrance to the muddy road, correct?
Yes.
All right. And eventually, basically an old key to the Bjorky gate was found, is that right?
That is correct.
Okay. Did the Crush alert on anything else along that field line, or along that ditch line?
Not that I recall.
Okay. And then you came back on another day when the back of the cell phone was recovered, is that right?
The back of the cell phone was found that initial night.
So, item 234 was found on what day?
That was found the initial night. It was located there.
What do you mean by the initial night? On March 22nd?
March 23rd. The initial night that I responded.
Okay, so the first time you were there, you found the back of the cell phone?
Yes.
Okay. And that is in Exhibit 283, was up here by EB, is that right? Approximately?
Is there a diagram that says what each of those items means?
There is, but I can't tell you.
Okay.
So you have to go off of your memory. Do you recall which one of the items the back of the cell phone was, A, B, or C?
Not without, I can't tell you for sure.
But that was found on the night of the 23rd, you said, right?
Yes.
You made a report about your recovery of that, did you not?
My initial report does state that we located that and there was the footprints.
Did you make out a report, sir?
Yes.
All right. The report is DOJ 184 through DOJ 188, which I'm showing you now. Is that fair to say?
Yes.
And the date on that report begins on actually March 24th, is that right?
Yes, that's a typo on my part. That should be the 23rd.
Okay, so your report is wrong, but your memory is that it's on the 23rd.
Yes.
Okay. And on the 23rd, you say when you were there doing this work, you were informed by, you know who Sergeant Day is?
Yes.
And Sergeant Day, so you found the back of the cell phone prior to finding the vehicle?
No.
Do you know what day the vehicle was found?
March 23rd is my recollection.
Okay. And so you showed up after the vehicle was found, it was that same evening?
Yes. It might have been the early morning hours when the phone was found. I don't know the exact time.
And, well, let me ask you this. Your report says on March 24th, I was off duty at about 7:30 p.m. and I was contacted by Sergeant Rich Day. Is that right?
That's what my report does say, yes.
Okay. And what you're saying is it's accurate other than it's March 23rd, not March 24th, correct?
Yes, my day was off in there.
Okay. And so you would agree on March 23rd at 7:32 p.m., it's dark out, correct?
Yes.
And it was the day after March 23rd, after it was dark, the next day, when you searched the lines and you found the cell phone. Agreed?
It was still dark out when we were walking that ditch line when we found the back of the cell phone.
Okay. And it was the back of the cell phone that Sergeant Day informed you had been run over by some kids biking. Is that right?
Yes.
So some kids were out there biking near the crime scene in the dark on this evening?
He had made that observation when he arrived on the scene. I didn't make that observation.
Okay. But you, all right, we'll ask the Sergeant Day about that then. Thank you. You observed foot tracks though eventually, correct?
Yes.
And the foot tracks that you're talking about are in the shoulder area on the south side of 430th Avenue. Agreed?
Yes.
And those foot tracks that you observed led you to conclude that it looked like the person was dragging their feet a lot. Is that right?
They were long drag marks.
Okay. And by long drag marks, it appeared as if the distinct toe marks, as in the person was not picking up their feet as high as they would, and when they pulled it forward, it drug along the ground, correct?
Yes.
You photographs of those footmarks and where the tracks show that somebody's foot is dragging along there?
Sergeant Stalker, I believe, took those photographs.
Okay. And have you observed those photos?
I didn't look at them afterwards, no.
Okay, but what you remember seeing on that day is footmarks of feet dragging through the sand, right?
Yes.
You've had many different tasks in this investigation, is that fair to say?
Yes, it did.
One of your tasks was, well, you're familiar with the journals that were recovered from Alex Woodworth's house, is that right?
Yes.
You're familiar with the books that have been, some of the books that have been recovered from, you're familiar that books were recovered, agreed?
Familiar with books that they were recovered.
That's not your type of reading material, agreed?
That's correct.
And so one of the things that you were asked to do was to reach out to a philosophy professor about the journals in those books, is that right?
Objection, relevance.
Goes to relevance, I can tie it up or we can talk it on the side.
Overruled. Yeah, again, I'm assuming you're not
I'm not getting into the
diving in
content.
at this point.
Not
All right,
getting into
go ahead.
But you were assigned to contact a philosophy professor, correct?
I was.
And as part of that, you gave the philosophy professor information, is that right?
Yes.
You gave the philosophy professor, for lack of a better term, Alex's journals, right?
Yes.
And you also gave the philosophy professor a defense motion, is that right?
I did not give him that, no.
You're aware that the philosophy professor received a defense motion,
Objection,
correct?
relevance.
Goes to credibility, bias. I can tie it up if you're.
I'm going to overrule. It's cross-examination.
You were aware that the philosophy professor was provided with a defense counsel motion, correct?
I was made aware of that, yes.
You were made, and the defense motion was information about what the defense said happened out on that muddy road. Agreed? For lack, I don't want the content, but just in broad strokes, it's essentially what the defense says happened out on that muddy road, correct?
Honestly, I didn't have enough time prior to that to read all of it, so I don't know exactly what was all in there.
Okay, and you don't know who provided the philosophy professor with the defense motion?
I don't know for sure, no.
Okay. Do you know who Dr. Tillotson is?
No, I do not.
You're involved in the investigation in this matter and you don't know who he is?
I'm not familiar with that name, no.
Okay. Do you know if, so you wouldn't know whether anybody from the prosecution team gave Dr. Tillotson the defense motion, which laid out everything that the defense says happened out on that muddy road?
Objection, relevance.
Goes to bias and credibility.
Yeah, I'm going to overrule.
You don't know whether the prosecution team gave that information to him, do you?
No, I don't.
Nothing else.
Okay, any redirect?
Did you find the back of the cell phone?
I was not the one that discovered it, no.
Okay, nothing else.
All right, any recross based on one question?
No, thank you.
All right, thank you. Sergeant Mayor, right?
Yes.
Okay, I believe that you are free to go. So have a good day, sir. Does the defense have any other, or I'm sorry, the prosecution have any other witnesses today?
He'll take longer than 10 minutes, that's for
Well,
sure.
how long do you think you'll take?
Half hour, 45 minutes?
Now, we have a couple jurors that need to get out by 5.
Okay, well, I'll tell you what, we have some things to do after the jury leaves for the day, so I think this is a good spot then to let the jury go for the day. And again, I want to remind all of the jurors not to read anything about this case, not to do any research on your own, not to watch any coverage or listen to anyone talking about this or asking you any questions. Very important, again, as I had indicated previously, and I don't have that instruction right next to me. I was going to read it to you again. But again, anything that you see or hear outside of the courtroom is not evidence. And there's a big risk that, your memory could be contaminated and you could bring contamination to the rest of the jury. So as you can see, in this trial and how much work this trial is for everybody, including you, the jurors, we want to make sure that you follow all those rules and don't expose yourself to any media, television, radio, internet, social media. You know, there's so many different ways people get information in this day and age. Neighbors, friends, relatives, just do not talk about the case or do not listen to or look at any information about the case, okay? And then what we're going to do, I'll just let you plan ahead a little bit. We plan to start with evidence tomorrow morning at 8:30 a.m. So if you're here, again, prior to 8:30 a.m. start. And Wednesday morning for the jury, it's going to be, I believe, a 9:30 a.m. start. I have to do our drug court on Wednesday morning, and that usually is done before 9:30. So that's when we're going to start with evidence on that day. So if you have anything on Wednesday morning, you can start a little bit later. Okay, with that, then we'll excuse the jury. All rise. All right, first one I have is approximately 1:38 p.m. and it related to, I believe it was exhibit 654, whatever it was, related to Alex Woodworth's journals, and in particular, a sidebar related to basically the court. There was an objection to going into that at this time. There's been a pretrial ruling as it relates to Alex's journals, and the defense had requested to at least be able to, at this time, go into what was 4 different doodles, basically. Again, pages identified, and the court allowed Mr. Nelson to go into that to some extent today. Again, the defense has a certain amount of time if they choose at some point to introduce evidence related to those journals, but the court was concerned that today was not the day for that, given the number of witnesses and trying to make sure we keep this moving. So in any event, there was some latitude given to Mr. Nelson, and he presented some evidence related to those pages 1, 25, 27, 35, I believe, and that's to that extent. State objected to this, and so it was partially overruled, I guess you might say. Anything further either counsel would like to put on the record about that?
No.
Okay. The next sidebar, that was approximately 1:50 p.m. and 1:55. Those 2 sidebars were related. There were questions of now Officer Kurtzel's former investigative Sergeant Kurtzel's was asked questions on cross-examination about some investigation done for mental health providers related to Ms. McCandless. And state objected on relevance, and Mr. Nelson essentially argued related to evidence that is anticipated to be introduced later. And so either counsel wish to put anything on the record related to that?
The state's position is, given the change in plea, any of questioning along those lines was irrelevant, but I understand the court's ruling.
All right, Mr. Nelson, anything you'd like to say about that at this time?
No, thank you.
Okay. Well, the court is not going to comment on that further because it relates to evidence that has not yet been received into the record. However, from the court's position, assuming that evidence, or for sake of argument, approximately 2:11 p.m., there was a sidebar, and this related to, I believe it was Exhibit 262, and the phone celebrate extraction or data extraction of Jason Mengel's phone by former Deputy Conkey. And I believe that it was basically related to that understanding that we're not going into the content, that would be a separate issue, but that this was just related to the understanding that this was for the process, that this was in fact the data extracted, the media that contains the data extracted from Mr. Mengel's phone when Deputy Conkey had extracted it. Anything further either counsel would like to say about that?
No.
Okay, and the court did then, and again, that was just, it really wasn't so much of an objection as just a make sure that we didn't go into the specific contents at this time. Okay, and I have at 2:30 p.m., there was a sidebar related to a hearsay objection. And Captain McRoberts was testifying, and we got to a point where there was a question that related, or he was in his answer talking about getting a phone call from then investigator or Deputy Conkey. And we had a sidebar, and there was basically a discussion that there was an understanding that they weren't going to go into the specifics of that and go directly to, I think, the issue of him having searched a particular area and then finding his cell phone. But I don't think the specific hearsay was ever related. Mr. Nelson, anything further on that you'd like to say?
No, Judge.
Okay, Ms. Nordahl?
No.
All right, then it takes us to 246. There's a sort of a double sidebar related to the Instagram account of the defendant. The actual, first the sidebar, there was an objection about saying what the Instagram account was. We'd had a previous discussion and an order by the court prior to opening statements that I'm not sure how to characterize it. It wasn't exactly a moniker, but a comment on the Instagram page. But the defense was objecting to the actual use of that at this time, for the same reasons it objected to the use of it in opening statements. And but the actual name of the account was allowed, and that was clarified that that's all they would get into at this point, and that related to the name. But on the second sidebar, the defense was asking that that be bleeped out so that that particular account would not be blown up because of the coverage of the trial. So I'm not going to repeat the name of the Instagram account at this time, so we don't have that problem repeated. But in any event, anything further counsel would like to say about that issue?
No.
No, Judge.
Okay. All right, counsel, any other sidebars the court has missed?
No, Judge.
Okay, anything else that either counsel would like to put on the record? I guess starting with the state, given they're presenting their case in chief.
Yes, there are two matters that I'd like to address before we close for the night. The first matter, one of the earlier witnesses tomorrow is going to be Kevin Scott, who's the DNA analyst. And when we had, before we, I don't remember if it was before we started the trial or early on at least, we had raised the issue of one of the swabs from the sexual assault nurse examiner kit, which was the Mons pubis swab of the defendant, was a low-level mixture of at least 3 males. It says the profile is suitable for exclusionary purposes only, and then the only thing they can say about it is that the possible contribution of DNA from Alexander Woodworth and Jason Mengel is inconclusive due to the limited amount of genetic information available. We don't believe that any of that any of the results from that are relevant or admissible, and the fact that it can't exclude them, it just says the possible conclusion or contribution is inconclusive. I don't think that evidence is admissible at this point in time and in this matter, and so we would just ask that Mr. Scott not be asked about the Mons pubis swab.
Is there just one Mons pubis swab?
Yes, Your Honor.
And how can that be identified, at least from the reports or your DOJ documents? So
It is on page DOJ 001876. It's the report, the crime lab report dated November 14th, 2018. It's labeled report number 13 for case number W18-603.
All right. And Mr. Nelson, did you want to address that issue?
Yes, just briefly now, I don't have the report in front of me. I wasn't prepared to make the argument, and so I'd like to be able to talk about it tomorrow, but just briefly, the state has the burden of proof. And as we all know, one of the jury instructions is they can consider the evidence as well as the lack of evidence, as well as any reasonable hypotheses consistent with her innocence. If the state wants to present evidence that they had an area tested and that test excludes one person, I think the defense should be able to say, but it doesn't exclude this other person. They tested it to try to exclude Alexander Woodworth, and they were not able to exclude Alexander Woodworth. That is relevant information. That's what we should be able to ask about. Did you test that? Did you do that?
And imagine it doesn't exclude about 10 million other people. Okay, well, I'll start over.
I'm sorry.
Briefly, Judge, Your Honor, I believe, was saying, well, it doesn't exclude 10 million other people. They didn't test for 10 million other people. They tested to try to exclude Alexander Woodworth. They tested to try to exclude Joshane Carlin, and they tested to try to exclude Jason Mengel. I don't know that they tested to exclude anyone else. And so the 10,000, 10 million doesn't matter. They didn't test for all of those other people. They specifically tested to see if they could exclude Alexander Woodworth, and they were not able to do so. And then if I could, I know we're not normally tag teaming, but it looks like Ms. Vishny has some things to add. Is that appropriate, Your Honor?
That's fine, go ahead.
Thank you. Again, I don't have the report in front of me, and the DNA experts are not my witness, but I'm well aware that the crime lab frequently sends out a very minuscule amount of DNA cells to a company called StarMix, STARM, I don't know if it's MX or MIX, or there's also another company called True Allele, ALLELE, and these companies can take extremely small amounts of DNA and use something called probabilistic genotyping. There's a lot of controversy around it, but I have seen StarMix used by the Wisconsin State Crime Lab, and I don't believe they did that here.
Well, first off, and a couple of things about
But
this.
I could be wrong, because I don't have...
No.
Hold on, let's talk over each other. I'm switch over to Mr. Dufour.
This was only a YSTR analysis, number one, so they couldn't do probabilistic genotyping. That only works with a full DNA sample. This was a YSTR. And if counsel believes that somehow the fact that Alexander Woodworth and Jason Mengel, their possible contribution is inconclusive, then I think it's also then important and relevant that it's a low-level mixture of at least 3 males. If we're going to have it in, we're going to have the whole thing in, not just part of it.
All right, well, what I'm asking the defense to do is if you can tell the court tomorrow morning, and again, we'll start at 8:15, you tell the court why that would make any proposition of significance in this case more likely or less likely. It sounds to the court that, and we've argued about this before, and I've read it, I want to review that, but it seems to me that it's a no opinion. It's like they can't give an opinion. It's not a clearly it can be excluded or it can't be excluded, or that our opinion is we can't exclude him as being a contributor to this. And also why, if part of that came in, why the rest of it wouldn't come in. As I understand it, there was, it's a non-opinion, which could be very misleading and confusing. And so that's how I look at it at this point in time. But we'll give everybody a chance to freshen up your review of this material before we argue on it further.
And I will tomorrow, but I understand Your Honor's position about the non-opinion. I'm not asking his opinion. I'm asking whether he could or he could not exclude somebody. His opinion about whether he could include somebody is different. I'm asking whether he has an opinion that he can exclude somebody. And so I think that's the other side of the same coin perhaps, but it's it's on a more firm footing, and I can articulate it in more detail tomorrow morning.
All right, well, we'll give you a chance to do that in the
Yeah.
morning. Okay.
And the other concern I have, Your Honor, deals with the method of asking questions that counsel, especially with the last witness and some of the last questions that counsel asked on cross-examination. I have some concerns about that. Counsel asked Sergeant Mayer if he was familiar with Dr. Tillotson. He said no. And then to ask a question, are you aware if he was given something which implies that Dr. Tillotson was given things that it was somehow improper for, and then arguing that it's to show something about credibility, believability in front of the jury, when it's clear the witness cannot know if Dr. Tillotson got him, if he doesn't even know who he is. And to ask that question in front of the jury and then imply that it somehow has something to do with credibility of Dr. Tillotson, I think is very inappropriate, and to do that in front of the jury is extremely inappropriate. I would ask the court, advise counsel to not ask questions unless he has a good faith basis to believe that the witness knows an answer that's relevant, and when he doesn't know an individual, and the same types of questions were asked repeatedly of Dr. Tillotson about BDSM and various things relating to BDSM, when he said he doesn't know anything about it, and they imply the existence of certain things and imply the existence of certain facts, when it's clear the witness has no knowledge about it and the counsel has no reason to ask that witness that information.
Judge, there was objections in the trial. Your Honor overruled those objections. I don't believe it's appropriate for the state to ask Your Honor to lecture me or chastise me or do anything else. They make objections in the moment. They did. Your Honor overruled it. I asked appropriate questions. They're ethical questions. I have a good faith basis to ask the questions that I did. And if anyone wants me to articulate it more, I'm happy to do so. But I stand by my questions. I stand by my ethics. I'd rather they not be questioned by the state, especially by an attorney who wasn't participating in that examination right here, right now. And so I think it's inappropriate to bring it up here and now in court where somebody is. I'll just leave it at that, Judge. We were professional for 6 days, but apparently it ended.
All right, well, I will say counsel have all seem to be very professional here, so, but again, I think the state is, I think they have a legitimate concern, and I'm not saying that you've done anything improper, Mr. Nelson. They maybe just don't know where you're going, and I'm not sure where you're going, but cross-examining in areas of bias and credibility and things like that, I mean, that's fair game, but it is not appropriate to be suggesting something exists out there, planting that seed in a jury's mind if you don't have something. I don't know what you have. I don't know where you're headed with it.
I'll tell you right now what I was doing.
Well, if you would like to make a record of it, I'm just saying, from this perspective, sure. I'm not going to be, I want to give you an opportunity to fully cross-examine, but there certainly are, if we're getting to a point where something is, close to the line, but
I was not implying anything was given. In fact, my point was the exact opposite. My point that was things were given to one witness, but they weren't given to a different witness. And that different witness, Dr. Tillotson, had specifically testified that his opinion was based upon limited information. And I was just buttoning up and adding to the fact that he didn't have certain information. The state has chosen to provide information to some of their expert witnesses, and they've chosen to not provide that same information.
got a list of the witnesses.
Carissa Wobler, Kevin Scott, Aaron Mattson, as stated, Deputy Day will probably be.
Okay, and does the state have an idea who they are calling, who you are calling tomorrow?
Judge Carissa Wobler, Kevin Scott.
Wait, I'm sorry, this is going a little too fast for me.
That's pretty slow, counsel.
Just write down the last name. You've got a list of the witnesses.
Carissa Wobler, Kevin Scott, Aaron Mattson, as stated, Deputy Day will probably be inserted somewhere in the day. Investigator Jason Stalker, and Joe Shane Carlin. If we get, I'm sorry?
Not Debbie Carlin.
Not tomorrow, no, if at all.
All right.
Judge, and that's as far as we have. It's possible, depending on how long those take, we might have to squeeze a couple in at the end of the day, but that's as far as we're comfortable giving an order on.
Are there any witnesses that you believe the court should prepare for in terms of any case law or significant issues?
Outside of the indication we had as far as Kevin Scott, I don't believe so, Your Honor.
Is there any data, content of data that you're going to get into with Mr. Stalker?
Defendant's journals.
So we're going to probably want to be heard about her journals, Your Honor, based upon previous rulings about what could and couldn't be in there. And so I understand that there was talk of the procedure. There's been other evidence, but there's also talk of prior sexual activity that's outside of the scope, I believe, of what Your Honor has ruled regarding the Jason Mengel, John Hansen. And so we'd like to be heard at some point, obviously not now, about some of the other information in those journals about prior sexual activity.
All right, and do you have a specific motion? You know, you had a motion that was filed that hasn't been completely addressed, and that was the motion related to electronic communications, I believe.
This is separate
Text
from that.
message. And, but if it's the journal I'm thinking of, you're talking about, you know, where it all began or where it started, something along those lines? Is that what
I
you're?
believe there's a journal called Silence Broken and
Silence
another
Broken.
one called Journal 2. I don't know if they're referencing both, but in either and or both of them, there is information that I think should be excluded based upon Your Honor's other pretrial rulings because it does not involve John Hansen or Jason Mengel.
Okay, well, given the defense sort of change of position with respect to the procedure.
And I'm not talking about the procedure.
So basically, what precedes that in Silence Broken,
There's information about her childhood as well as her activities in the city other than Eau Claire when she was in college, which precedes her ever meeting Jason Mengel, her ever meeting Alex Woodworth, her ever meeting John Hansen. There's some of that information in the journal which I believe, under Your Honor's previous rulings, should be excluded from those writings.
all right, and what is, again, I don't know that I have Journal 2. And obviously I can't rule on something unless I see it. But what is the state's position with respect to Silence Broken?
Sure, if the defense could let us know what portions they are objecting to, then we could discuss it and inform the court. This was part of a number of pretrial motions, and so I guess I'm a little caught off guard because I thought we had this ironed out, and this is.
Well, I think
months ago,
I don't think it was entirely ironed out. And I don't know whether there's a challenge to, again, authenticity or if it's the content.
It's the content.
Okay. And from my recollection, and again, I have to go back and look at the provisional ruling, but it seemed to me the court had ordered that, you know, what really preceded the fall of 2017 as far as the defendant was really not relevant to this case. Is that, anyone understand that differently?
That was my understanding, Your Honor.
Your Honor, I have a copy of Journal 2. I'm going to give that to the court. You have a copy?
Yes, I have. Thank you.
Just so the court has it, since you didn't indicate you were not familiar with it, so.
Yeah, I think I have that, or had that. I mean, have it somewhere in the electronic file. All right, and you plan to get into that with Investigator Stalker sometime?
Yes,
You anticipate that to be later in the day?
yes.
All right, is there anything else other, you know, like text messages or any posts?
Not tomorrow,
Okay,
but in the future, so.
all right. Well, again, it's helpful if, the court can be alerted ahead of time so that, we can use our jury time as efficiently as we can and cover some of these issues before and after the jury is here. Okay, anything else either party wants to take up today?
I just want to make sure, and I appreciate that it's a dynamic process, but just obviously Jason Mengel is a witness that is going to involve a lot of these texts or other information. And so it's my understanding that he's not going to be called tomorrow. I just want to confirm that so we don't have to go through and be prepared to argue that tomorrow. If there was a chance to do that, we'll do the preparation, but I trust that they're being as honest as, they're telling us in good faith, and I have no reason to not believe that, so we're just not going to deal with Jason Mengel tomorrow.
Right, Jason Mingle will not be tomorrow, but that being said, there are a number of messages that I think will need to be ironed out prior to him testifying. So if the court wants to set aside some time, at the end of the day tomorrow, so we can iron those out before he testifies later this week, I think that would be wise.
Do you have a general idea of when he might be called?
Wednesday.
So maybe we need to go a little bit later after we let the jury go tomorrow to address those issues tomorrow evening, evening. All right.
There are like hundreds and hundreds of pages of text messages between Mr. Mengel and Ms. McCandless. So I am really not sure what the state intends to introduce of those, but I would ask then that by the end of the day tomorrow, perhaps they provide us with which ones they actually intend to introduce through Mr. Mengel.
Has that been narrowed down?
Judge, that has been narrowed down quite significantly, and I have no problem sitting down with the defense and kind of showing them what the state intends to introduce, generally with the understanding that if something comes up, a question's answered differently than anticipated, defense asks something that needs to be addressed through a document, we're not restricted to specifically those items that have been previously laid out, but I don't have an issue with giving some insight into what specific messages, photos, et cetera, will be brought in through Mr. Mengel.
All right. All right. Well, again, I would appreciate counsel doing that to narrow the issues down a little bit so we can save some time.
Perhaps if the state could give me that over lunch hour.
Appearances, please.
The state appears by District Attorney Andrea Nodolf and Assistant Attorneys General Richard Dufour and Peter Hahn.
Ezra McCandless appears in person and with her attorneys Aaron Nelson and Deja Vishny.
All right. Is our counsel ready to argue the issue related to the DNA issue among many related to Kevin Scott? My understanding is that there really only were two issues related to the testimony, the DNA evidence that counsel wanted to decide ahead of time. Court has decided one already, and that is excluded at the defense request DNA evidence, finding it irrelevant, and that there's already a record on that, so I'm not going to discuss what it was. But what is that issue is what we talked about yesterday afternoon, and that being this finding with respect to some genetic material from a mons pubis swab from Ms. McCandless, as I understand it, from the sexual assault examiner kit, and that would be on a DOJ reference would be DOJ 001876, and This, in the court record, this is page 14 of 21 from document 151, filed in this matter on February 13, 2019, and it relates to the YSTR DNA results and conclusions related to the Mons Pubis swabs. Now, Mr. Nelson, I want to let you go first, as I believe it's the defense motion to, I'm sorry, it's the state's motion to exclude that evidence. Okay, so Mr. DeFore, you go first.
Yes, Your Honor. The state's belief is that it's essentially irrelevant, non-evidence. It doesn't tell us anything. It just tells us that we can't exclude Alexander Woodworth and Jason Mengel, or actually it doesn't even tell us that. It says it's inconclusive due to the limited amount of genetic information available. It doesn't exclude them, it doesn't include them, it just doesn't say anything. It's inconclusive. And Your Honor, and I understand that the court has ruled as it relates to the other matter, but I think that was our understanding of that ruling, and our belief on that is that it essentially meant that there was nothing on this that was relevant. And I think it would be disingenuous, and I think it would be misleading to the jury to tell the jury that the possible contribution of Woodworth and Mengel is inconclusive without telling the jury that it's a mixture of a number of individuals. Because, you know, if you tell them it's inconclusive as to two people, they may wonder, well, what does that mean? And certainly the fact that it's a mixture makes that even, number one, it makes it more difficult to determine, and number two, and more importantly, it means that it could be both, could be neither, could be, you know, other individuals. And so you know, that's why we believe the fact that it's a mixture becomes relevant if this becomes admissible and if this comes in. But if it all stays out, then that makes the most sense, because it really doesn't mean anything. It doesn't say that Alexander Woodworth is even possibly the contributor to this with any degree of scientific certainty. It's not like it says, for example, with the right upper thigh swab, which is the next item on there, that profile is consistent with the profile of Alexander Woodworth, and then gives a statistical reference of 1 in 1,773 individuals, which is obviously not a very great match, but it's, you know, about the best you can do with YSTR. But this doesn't even say that. It doesn't even say it's 1 in 2. It doesn't even say it's 1 in, it just says we don't know. And to say we don't know is somehow relevant in this case because it doesn't exclude Alexander Woodworth or Jason Mengel is stretching the possibility of relevance.
Okay, Mr. Nelson.
Don't need to quote 90402, the definition of relevant and probative value. It just needs to have the smallest, slightest possibility. And just so we're clear, I'm referring to DOJ 1832. I know Your Honor made reference to a article. I don't have that filing in front of me, but I think we're talking about the same thing. As the page you're referring to is page 8 of 11, marked DOJ 1832, Your Honor.
Well, it's page 8 of 11, report number 13.
Okay.
But my deal with the DOJ number is 001876 on the page that I have. And
I think there's duplications, but it is page, I'm referring to report number 13, page 8 of 11, about 3/4 of the way down, the bold type Mons Pubis swabs.
It's the same. They're just two different copies of the same record in the discovery.
So, Your Honor, as I was asking Your Honor, we're talking about the Mons Pubis swabs, item W10A. Is that correct, Judge?
yes,
All right. What my intended cross is to deal with the term exclusionary purposes. As Your Honor knows, both the definition of relevancy under 90402 as well as the burden of proof under 140. It's the defense position that the state needs to exclude reasonable hypotheses. And so my cross-examination of Mr. Scott could go something along the lines of this. You had a swab from Ms. McCandless's mons pubis. You tested that swab. You developed profiles from that swab. As a part of that testing, you then, the profile was suitable for exclusionary purposes only. And as a part of that, you were not able to exclude Alexander Woodworth from that profile. That's the extent of the cross-examination. I don't intend to get into consistent with, because that's not what his opinion is. I don't intend to get into possible contributions, because that's not his opinion. His opinion is the profile is, quote, suitable for exclusionary purposes only. So he tried to exclude Alexander Woodworth, and he was not able to exclude Alexander Woodworth. I think that's relevant.
Well, okay, so what do you think it is relevant of? And would you please put your microphone on during arguments?
Apologize,
Judge. It is relevant to the defense theory that I think we're going to tie up once it's the defense case, but as we've, I understand it's not evidence, but as I laid out in our opening, that Alexander Woodworth did things to Ezra McCandless. His hands, his body, his use of the knife were in certain places on Ms. McCandless. And the fact that we are proposing that, and the state has taken swabs of Ms. McCandless in those areas where we say he was near or on or there, they can't exclude through scientific evidence that what Ms. McCandless will be testifying to is in fact true. It's relevant to that portion of it. Their job is to rule out reasonable hypotheses. We are going to present a reasonable hypothesis. They cannot exclude that based upon this DNA evidence. That's why it's relevant.
Okay, well, again, and I'm going to look at this in the light most favorable to your client, and that is the story that, and I guess maybe that's a poor choice of words, but what you presented during your opening statement and what an offer proof has been in motions and so forth, as I understand it, and correct me if I'm wrong, but that at no time were her pants removed, that anything in that area related to cutting with a knife through the clothing, and that I haven't heard any proffer or any statement during your opening statement that there was any contact on this date by Mr. Woodworth with your client's mons pubis. I haven't heard a thing about that. Now, I add to that we don't know what type of genetic material it was, and it also indicates a mixture, and the finding is that it is suitable for exclusionary purposes only, and I read that to mean that it's not suitable to include anybody. So there's one person excluded, but again, the finding is that there's not, or due to the limited amount of genetic information available, that it is simply inconclusive as it relates to the other two individuals listed. Now, when I look at this, I just, when you talk about relevance, in the court's opinion, it doesn't make the proffered testimony, and again, Ms. McCandless has not testified. She does not have to testify. She has an absolute constitutional right to not testify, and we haven't reached that point yet. But assuming that she did, and it was consistent with what counsel has said in opening statement, in the court's opinion, this would not make that version of events or her testimony or that, however you want to characterize it, wouldn't make it any more likely or any less likely. We know that Mr. Woodworth was found in her vehicle. I mean, that evidence is in. We know that they were spending the day together. It wouldn't be a great surprise to find his DNA all over the car. I'm sure with the blood and so on and so forth, you're going to find his DNA. And so, that this particular finding, in the court's opinion, if there's any relevance to it at all, the probative value is so small that it is far outweighed by the danger of misleading the jury, confusing the issues, and being misused. So the court is going to exclude, again, the report of analysis related to item W10A as previously identified here on the record. It absolutely has no relevance. But again, your objection is preserved, and I'll, for the record, Ken, I know that the defense objects to that, but that's, again, preserved for the record.
And I'm not trying to re-argue it, I just want to make clear, so both the portion, two things above that, cervical swabs, that's excluded, mons pubis is now excluded, so there'll be no reference at all to any testing, anything at all regarding item W3A and item W10A. So there should be no questions whatsoever about those two items, is how I understand Your Honor's ruling to be.
That's consistent with my recollection as it relates to item W3A as well. And is the state on the same page with that?
I guess my only thing is that Alexander Woodworth is excluded from that one, but again, I guess I'm not gonna, I think that's relevant, but to the extent that, we want to just leave it out, that's, I guess, fine.
Well, here's, I guess, the court's position
Ruling about that.
is that if there was testimony, I mean, there's no proffer of evidence at all that that intercourse took place, or that given the events as described, again, I don't want to call it, I just want to be careful what I call it. I mean, I don't want to characterize it in a way other than neutral, but if the proffer by the defense, and I'll just say essentially the opening statement was a proffer of evidence, there was no intercourse. There was no penetration. I hadn't heard anything along those lines. As I understand it, what was the defense expects the evidence would show is that there was this event that took place in the back seat of the car, but that no pants were undone, that there was some cutting with a knife through the clothes in the exterior from outside with clothing on, and then Ms. McCandless had the knife, and there was no sexual activity or sexual contact that is proffered to have taken place. Essentially, the defense proffer was that it was an attempted sexual assault, but that there was never any contact, any sexual contact or sexual intercourse. And so I think that the evidence related to W3A would only be relevant for the state if there was that claim that intercourse took place. So given the version, again, it was that you stated on the opening, Mr. Nelson, there would be no expectation to find Mr. Woodworth's DNA in Ms. McCandless's cervix.
And I'm not trying to argue, I'm just trying to clarify, Judge. I apologize if I wasn't clear about that. I just wanted to make sure that I knew what the rules were going into this, what the rulings have been. And so if that's Your Honor's ruling, item W3A, we don't talk about, item W10A, we don't talk about, the defense now would move that item W9A, which is in between those two, for those same reasons, both scientifically, based upon their opinion that it's not suitable for comparisons, as well as just the relevancy arguments, I would ask that W9A
be excluded for the same reasons Your Honor's already articulated.
Well, does the state have any objection to that? W9A,
No, 9A is just basic. The only thing that concerns me, Judge, and it's not a huge concern, but it does concern me a little bit, is the jury did hear that that there was, these swabs taken by the SANE nurse as part of her exam. And I think what would probably be appropriate, there may very well be, and defense may bring in the swab, the next one, which was the upper thigh swab, which is consistent with the odds that I just gave. But I think it would be appropriate to ask ask just one simple question. Were any of the swabs, did they give you anything of any evidentiary value? And the answer would be no. Just so that the jury understands it was tested and we didn't get anything.
I think I would object to that question. I don't know when Mr. Scott is going to be testifying, but I would entertain the entering of a stipulation regarding item W3A, W9A, and W10A. I don't have the wording of it right now, but I would certainly entertain something so that we could alleviate that concern. I just don't think it should be in a question-answer format.
I'm fine with a stipulation that there's nothing of evidentiary value in them. That's fine too.
I'm not agreeing to the term "nothing of evidentiary value." That is a term of art that I don't think is accurate, and we can find some other term perhaps, but
Nothing that's relevant.
again,
we're getting closer. All right, well, we'll talk about that. When is Mr. Scott going to testify?
He'll be the third witness we're going to have, Your Honor, today.
Okay, so that gives you a chance to think about it. But again, as I understand the events, as the evidence is unfolded, that this SANE exam was done and these samples were taken because Ms. McCandless was not able to say what had happened. That's she didn't say. The fact is, she didn't say what happened. So they did the exam in the event that, again, later she may be able to say what's happened, and so. But the fact of the matter is, when she did say what happened, it didn't include sexual contact or intercourse actually occurring. And I haven't heard anything other than that or anything inconsistent with that. So I think that should be fairly easy to come up with a stipulation in that regard. So we'll then probably take a break and finalize that before Mr. Scott testifies. Okay.
That's fine.
And with that, are you ready for your...
One other thing, Judge, we'd just be asking the court to take judicial notice that the conversion from kilograms to pounds is it's to multiply kilograms by 2.2 and you get pounds.
Any objection to that? That's my understanding.
I don't know how that's relevant.
Well, but the court can take judicial notice of things that are on dispute.
It's relevant.
With that. I've done the calculation hundreds of times myself. You take 2.2 times the kilograms and you get pounds.
And it's relevant because we introduced the weight of the defendant at the hospital in kilograms. And so we want to be able to convert that to pounds so the jury understands what that meant.
All right.
That's the relevance.
Does the defense dispute that is, I think that's beyond...
Don't dispute the equation, no.
Okay, all right. All right.
Okay, yeah, that's fine.
Our position would be it's not relevant. I believe that it's in the medical records, the weight, and then...
In kilograms.
No, I think the medical records shows the weight in another form. I know Ms. Vishney wants to talk about that. There's also another thing she wanted to correct on the record regarding some comments she made yesterday about the DNA that I want to give her that chance. I need to go to the bathroom. I don't know if we're going to get a break before the jury comes in. If we're not, I could choose this time to run out and take care of business. All
right, why don't you take care of business? Anybody else?
Yeah, let me just, Mr. Nelson doesn't need to have to be here, but the kilograms to pounds and taking judicial notice, I would argue that's not relevant because basically what Dr. Tillotson said is he doesn't know where her weight came from, and there's no testimony that she was actually weighed by anybody at the hospital. So as far as we know, that's an estimate, so there's no real reason to draw any attention to that because there's no testimony that shows that that was actually her weight at the time, even though in the chart, that was said. So that's the reason why I'm opposing having that court take judicial notice of it. Does that make sense, Judge?
Well, it makes,
I'm not sure if I'm making myself clear.
it makes some sense, but,
Okay, I just want to make sure that my position is clear.
okay, well, understood. But
Okay.
the court is going to take judicial notice that the formula, if you will, is, there's kilogram is 2.2 pounds.
Well, I'm not disagreeing with that fact.
And so, frankly, I understand you don't believe it's relevant. I don't know if this weight's going to come up in some other way, but I'm going to make judicial notice that that is the formula.
Okay, I understand the court's ruling. I just wanted to briefly state that yesterday, I said something about whether or not YSTR could be sent for probabilistic genotyping, and I have investigated that, and in fact, it cannot. So it's really got nothing to do with what's happening in front of the jury, but I just want to correct myself.
Okay,
Thanks.
very good. All right, then, Ms. McCandless, does she need to use the restroom at all?
Yeah, she says she does.
Okay.
For the record,
Rich Day, D-A-Y.
what is your occupation?
I'm a sergeant with the Dunn County Sheriff's Office.
How long have you been employed in law enforcement?
Approximately 15 years.
During that time, have you received any specialized training with respect to death investigations or the handling of evidence?
Yes.
Could you briefly describe that training for the jury?
During my time with the Investigations Division of the Sheriff's Office, I've received between 2 to 2.5 weeks of death investigation training. I've attended, I've attended a 40-hour basic evidence technician custodian training.
On March 23rd of 2018, did you learn that there was a deceased male located near a field drive off of 430th Avenue?
I did.
What did you do after you received that information?
I responded to the scene after verifying location, responded to the scene, assisted in securing the scene, initiated a crime scene entry exit log to verify accountability on those entering the scene.
And do you recall calling the Department of Justice or other entities to assist with this investigation?
I did.
And why did you call the Department of Justice?
The Department of Justice has a crime lab scene response team that specializes in scene processing, evidence collection. It's their specialty.
And do you recall meeting with those Department of Justice crime investigators on March 23rd, 2018?
Yes.
And do you recall them examining some footprints on the muddy field drive?
Yes.
Do you also recall them placing flags in those footprints?
Yes.
May I approach, Your Honor?
May.
I'm showing you what's been marked as photographs 550 or 564 through 566. And what is depicted in those photographs?
Appears to be the foot tracks exiting the driveway. And my understanding is that is a flag for each footstep.
What about 565?
Appears to be further south down that driveway.
Also with the flags?
Also a flag for each footstep.
And what about 566?
566, looking back north toward 530th Avenue from the top of the hill.
And do these photographs accurately depict the flags in those foot impressions as you remember seeing them on March 23rd, 2018?
Yes.
Okay, move exhibits 564, 565, and 566 into evidence.
Any objection?
No, Your Honor.
Okay, exhibits 564, 565, and 566 will be received.
I'd request to publish those for the jury.
All right, you may.
And this is exhibit 564, and are those the flags as you recall seeing them? I guess it's,
Yes.
I might need to. I think with that glare, I'm gonna come back to it. It's pretty hard to see the initial flag. We'll just continue with some other questioning until we have that ready electronically. Sergeant Day, before leaving the crime scene on March 23rd, what, if anything, do you remember doing with respect to taking items of evidence?
I took custody of the items that were collected by the Department of Justice Crime Lab.
And what happened to the evidence after you took custody of it?
I placed them in Investigator Dykes' squad. They were then transported back to our office and secured in a evidence garage.
And do you recall what happened from the vehicle that was located down that muddy road?
Once processing of the scene was complete, we requested a tow company. The vehicle was towed in the presence of Investigator Dykes, followed back to our facility and secured in that same evidence garage.
And was it in an enclosed garage?
Yes.
And was it locked?
Yes.
If I could now display those photographs on the computer. This is exhibit 564, and are those the flags and the footprints as you recall seeing them?
Yes.
And then turning to exhibit 565. And are those the footprints from a different view?
Yes.
And then 566. And what position would you be standing in this photograph?
This would be from the top of that hill facing back to the north.
And is the north the roadway?
North is 430th Avenue, yes.
Okay, thank you. May I approach, Your Honor?
You may.
I'm showing you what's been marked as Exhibit 203. What is this document?
These are the Dunn County Sheriff's Office property inventory record sheets.
And do you recognize them?
Yes.
Did you create these property inventory record sheets?
The majority of them, yes.
And is it 21 pages long?
Yes.
And can you explain for the jury what you do with evidence when you receive it?
In a normal case, the handling deputy that takes the case completes the property inventory form, submits it for to be changed from temporary storage to permanent storage. That comes through the evidence custodians. I am one of the evidence custodians for our department. Items that they bring in get placed into a temporary locker. I remove them from the temporary locker into a more permanent storage.
And why are these property inventory records drafted?
To establish what evidence is taken in by our department as well as maintain chain of custody.
And were you generally in charge of the evidence in this case?
Yes.
And do these accurately reflect the property inventory records?
Yes.
I'd move Exhibit 203 into evidence.
It's 203?
Yes.
Okay, any objection to Exhibit 203?
Yes, it's irrelevant. 90403, happy to approach on the side or take it up later. equipment, 90403, happy to approach on the side or take it up later.
All right, well, I'll tell you what, we'll take that up. I'll just withhold ruling on that at this point. Okay.
And as part of your duties in this case, do you recall receiving and placing into evidence the defendant's clothes?
Yes.
Turning to page 6 of Exhibit 203. Are those some of the items that you received in relation to the defendant's clothes?
Yes.
And if I could have you step down and put on some gloves.
It's 203?
Yes.
Okay, any objection?
Approach on the side or take it up later.
All right, well, I'll tell you what, we'll take that up. I'll just withhold ruling on that at this point. Okay.
And as part of your duties in this case, do you recall receiving and placing into evidence the defendant's clothes?
Yes.
Turning to page 6 of Exhibit 203. Are those some of the items that you received in relation to the defendant's clothes? That belong to the defendant. Exhibit 222, a blue button-up with white spots on it. Exhibit 223, a blue and white plaid button-up. Exhibit 224, a paper bag containing a yellow tiger shirt. Exhibit 225, jeans. And Exhibit 226, a gold sweater.
You do not object to the introduction or publication, Judge?
All right then, ladies and gentlemen, exhibits 221, 222, 223, 224, 225, and 226 will be received into evidence. Madam Clerk, do you have all those? Okay.
Sergeant, if you could start with exhibit number 221, a pair of gray leggings. Are those the same leggings you recall from this case?
Yes.
And if you could publish them for the jury, if you could lift them up. And then if you could also flip it around, perfect. Thank you. Yeah, I guess if you can kind of roll it up and You don't have to completely package it.
Just place it back in the bag.
I don't think it even needs to go in the bag at this point. All right, and then after you get your new gloves on, we'll move to Exhibit 222. I believe it was on your property inventory record, item 31, a paper bag containing a blue button-up long sleeve shirt with white spots. It might be better to just put them back in the bag, actually.
No, I'm probably gonna ask a question.
No? Okay, never mind. White spots you remember from this case?
Yes.
Okay, thank you. It might be better to just put them back in the bag, actually.
No, I'm probably gonna ask a question.
No? Okay, never mind. Next will be Exhibit 223, a blue and white plaid button-up shirt, your evidence item number 32. Thank you. A yellow tiger shirt, your exhibit number 33. Or your item number 33, exhibit 224.